apologies from two members. Minister Main has had to move on from it today on a specific matter. But the minister not able to attend, and Senator Donna Scott Motley. I intended to make a comment relative to Senator Motley's request. Let's see. Well, we can go straight into business today. I said that request was made, Minister note and members, for 2 sets of data. Requests have been made to the DPP's office for the one dealing with plea bargaining and what has been used. So I hope we'll have it in time for the next meeting. I'll have to repeat my comment, but the request from Senator Scott Motley for, are you hearing me all right? Or we have this new fancy stuff here?
Yes, I'm hearing. Yes, I'm hearing.
And the request for data on mandatory sentencing. Well, there's some data and its use, and Minister, you'd have been more aware of them than I am. But the specific issue we're dealing with, there's no such data. And I don't want to keep the meeting in suspension. From my initial, I gather the actual countries and data requests, but on the preliminary review, all the countries who have had any kind of homicide rate of violence at the level that we have, or even urban center that can be designated, that can be identified in relative to the rest of the country, have never have never had any successful reduction by virtue of the approach we had, that's similar to what we're doing. All of their responses are more on the military side, and militaristic side. And what we're seeking to do is to introduce legislation that can go through our court system and that our law enforcement officers can use as legitimate tools to reduce extreme level of violence. It's of interest, I said that I spoke to a criminologist recently doing a study of the issue, and he regards this kind of approach along with the social investment program as he called a public health approach, and he thinks it's doomed to failure. I don't agree, but just that there are other opinions out there. And he thinks that strong measures are required and an efficient, well-trained police force in adequate numbers is the first step to mitigate the damage and the issue, and then focus on the medium-term solutions. Not overlapping, of course, which is the public health issue, but that's just my side. What I'm concerned about and wish to inform the committee members, I don't think we have any credible evidence that we can use to compare or to derive from. We'll have to find a country or a city that has similar homicide rate and has introduced a similar suite of legislation and train the police to deal with it. There isn't any such evidence. They have all adopted what we could term a military style operation, which we have not chose to do and would not like to do. So we'll have to, the government is based on its assessment, making a policy position to be executed and to monitor as we proceed and ensure that we remain within our constitutional framework. I think members may wish to come, but I think we can, I'll have to repeat that when the Senator Scott Motley is on, because I don't want to think I've ignored her requests, and she's always a contributing member to the committee work. We'll go straight to the business.
DPM, if I may.
Sure.
Just a quick question before you move on. Just so that I'm clear, are you saying that none of the countries or jurisdictions that you looked at have implemented these kinds of measures, or they implemented them but they haven't had any result?
They haven't sought to implement them in any way. They went straight to a more militaristic solution.
I see.
And with all the success they have had. That's not pursuing that line. Thank you. Okay, clause by clause, I think we're at page 10. of the matrix. All right, Amelia.
Page 18.
Yeah.
Page 18.
Page
18.
18, sorry. Sorry, 18, yeah. That's with the Jamaica, right? The association, Proactive Jamaicans and licensed firearm holders have comments under section 9. Manufacturer, purchase, device thereof. Comments on section 9.3. I think we have covered it already, but can I get the comments? So it's no person positive detailed blueprint with the intent of to manufacture a 3D printed firearm that is a prohibited weapon without a license permitting same. And be advised on this by the legal person, technical team. My simple interpretation is that no person shall possess a digital blueprint, so this it become illegal when you have the blueprint, not when you have the machine. But
Right.
So here seems that we need to be, there's a possibility of alluding to there.
So from the policy team, Minister, we had looked at it and we realized that it might pose a challenge. So we decided to more or less accept the recommendation to include a requirement in possession of the device must be the intent to actually manufacture the firearm. So therefore, the mere possession of a 3D printer or without more would not be criminalized.
Okay, that seems reasonable. Online, Senator, we'll have 3 distinct alternatives. Any comments on that from Senator Mr. Williams here?
Yeah, yes, Mr. Chairman, I think it's reasonable, the position taken.
Were you asking me a question?
Yeah, I was asking if your comment, I was legal senator and none of was answering that. The comment made by the policy team that they'll make amendments to ensure that there's clarity between ownership of a 3D printer versus having a blueprint with clear intent to manufacture a firearm.
Yes, sir, I agree with that position. It's prudent to make the
decision. It seems that the current clause, Senator, doesn't clarify, doesn't make it clear. Let's say that as a layman, that's what I see that, but it seems that it could be used. Well, I mean, section 9.3, it says no person shall possess a digital blueprint with the intent to manufacture a 3D printed firearm that is a prohibited weapon without a license permitting sale. The view of the commenters that could also imply that you should not own a 3D printer that can print such an instrument.
May I ask a question, Chairman of the team? All right. So right now, it is the mere possession of the blueprint or other device for the manufacture of the 3D printed firearm that has been made an offense. What is a digital blueprint for? Just remind me. And devices that can manufacture a 3D printed firearm, what else do they manufacture?
So a digital thing. Right, so a 3D printer can manufacture more than just a 3D printed firearm. The digital blueprint is any type of digital or electronic reproduction of a technical drawing of the design of an object. So in the instance of a firearm, it will be a digital blueprint of anything that can design a firearm. So what we were grappling with was the introduction of the or other device because based on how the provision is drafted, it would seem as though mere possession of a 3D printer may also pose a challenge. So the compromise that we had worked out, and we actually had an alternative, because in looking at the Singapore model, at the Singapore legislation, they actually included defenses to the charge of actually being in possession of such digital blueprints or such devices. The compromise that we being in possession of a 3D printer, 3D printer or such
they made that
so they have actually outlined instances where you can actually say that provide a defense for having those materials.
If you have the blueprint, Minister, if you have the blueprint and the printer, they can charge for the printer as well. But if you have you can't charge them for having a printer.
Right.
The printer is used, Minister, in not to make anything. Literally, I mean, I've seen a model that actually can print a house in a day, but it's material provided. Go ahead, Minister.
I'm just thinking, Chairman, if we're not prohibiting possession of digital blueprints, because they may be
the blueprint you're prohibiting.
You are prohibiting outright the digital blueprint?
No, not the printer, the print for firearm.
No, right. So is it the policy to outright prohibit possession of digital blueprint by persons?
Digital blueprint for a firearm.
All right.
Not,
so if the policy is to prohibit the possession of a digital blueprint for firearms, then we need to reword the provision. But who may lawfully possess a digital blueprint for a firearm? Who may lawfully do so? A manufacturer of a firearm?
Yeah.
Right. And
Minister, I'd love to see that as well, that if the person has the blueprint, then they can be charged for seeking to manufacture a prohibited weapon.
All right, so remember now, all prohibited weapons relate to two things: a certain category of weapons, and then weapons that have not gone through our registration system and are not recorded in our system. Is there anyone who may properly have the blueprint for a category of firearm which would be prohibited in other circumstances?
That would be possible, and I'm not interrogating the issue. We'll have the blueprint. The machine can manufacture pretty much anything if you prepare to spend the money to buy the particular machine. So they can, in fact, have a blueprint to manufacture a simple firearm, which would be prohibited because it's not registered or approved, since he's not a licensed manufacturer. But you can also get one that would manufacture an automatic weapon, which is prohibited in itself. So,
or Chairman, my query is directed at ensuring that you don't make the provision so wide, because as of now, it's no person shall possess. If by policy it is accepted that certain persons may lawfully possess digital blueprints, certain persons may lawfully possess printers, etc., then we can't cast the provision as wide as it is now cast. We have to be clear who it is that we are prohibiting from possessing these and for what purpose that you're prohibiting possession. So the response by Mr. Richards would only answer part of the question, by if the proposal now is to add with intent to manufacture the print, but it does not address the first part, that persons may properly possess digital blueprints to manufacture firearms. And those firearms, if they are appropriately authorized, would not be regarded as prohibited. So I think it's just some clarity is needed as to what exactly we're prohibiting and who we're prohibiting from being in possession of what, for the clause to not create a big problem.
I appreciate it, Minister. I think perfectly on target. You know, we have to define who, what, and also define intent. I don't know if the CPC want to comment, or we'll just prepare that and get it to you. And that's quite clear, as the 3D printer will become quite popular. All right. Thank you. The next, proceed to, I think the comments from Proactive Jamaica were along the same lines. And we're doing with the Rifle Association. The next section of comments we have to look at is the 11 prohibition of taking firearms or ammunition in pawn. Section 11.3 consists stating a fine or developing a methodology for determining the fine which is to be implied. This will be consistent with other fines stated through the document, as well as to establish a financial deterrent.
So, Minister, recall that we do not normally state fines when it's circuit court jurisdiction. So we're not.
And this goes to the circuit court.
Yes, that's it.
Minister, good grounds.
Sorry, DPM. The audio went out there.
Okay,
I didn't hear all of what you said.
Yeah, they in section 11.
Yes.
It's a breach for someone who operates a pawn shop to receive a firearm or ammunition, and that goes to the circuit court.
Yes.
Mr. Boucher was saying we should define the fine, and Mr. Richard is saying, well, the circuit court is not so guided. Normally, we don't indicate.
We do not normally, because the jurisdiction of the circuit court is unlimited in respect of, it's unlimited generally. And of course, in respect of fines, it's usually, we don't normally specify. Sometimes it may specify, sometimes it may not specify.
So it would not be necessary here.
Right.
That's correct. The next comment we get is on section 15, which refers to possession of a firearm or ammunition with intent to injure or cause damage. And how you define that, Minister, what we needed. The recommendation from this gentleman is that we increase the imprisonment for that to a mandatory 30 years. In light of the grafted intent to cause damage or injury, which is not far removed from an intent which results in death. Casualty, this section. Essentially, he's recommending that where there is clear indication of intent to commit a felony with a firearm, the mandatory should be 30 years. We have a challenge with 15. Minister, you may wish to comment.
We have introduced a regime that was thought out, and we looked at the types of offense, we put them on par. It's interesting that we're getting two kinds of reactions, almost on extreme. Some are expressing the view that we shouldn't legislate a mandatory minimum sentencing regime, albeit that it is already part of the Jamaican law. And others are saying that the sentences we have prescribed are not harsh enough. So if persons were to understand why the government has taken the position it has taken on possession, then this recommendation perhaps could, there may not be the need for it, because it is the view of the government that possession is the foundation on which all other offenses are committed. And like I said, the last time when the committee was convened, if a person is not in possession of the firearm without authorization, the person cannot use a firearm to then commit any of the many offenses, including ultimately the offense of murder.
Thank you, Minister. Yes.
Right? So that some persons may mistaken the use of the term possession simpliciter for simple possession. The policy stance of the government is that there is absolutely nothing simple about someone possessing a firearm for which they are not authorized.
Thank you again, Minister, for the clarity you bring discussing this particular issue. But as I said, the recommendation reflects the emotions of the society, and we have to remain on policy. But as I said, some are recommending less, some are recommending more. But what happens here? But it also answers the question if it means for all the what might be called additional, what else can be attached to having possession. The judges will determine how far they go, right, beyond the 15 years.
Yes, Chairman, a minimum means that it is a floor below which you do not go, as opposed to a maximum sentence, which is a ceiling above which you do not go. So it is always open to the court in an appropriate case, depending on how grave an example of the offense is, the antecedents of the offender, and all of the circumstances peculiar to the case, to hand down a sentence. What the mandatory minimum is saying, that the government as a matter of policy views action in relation to this kind of matter, even in the most lenient circumstances, to be so egregious that those who deliberately choose to embark on a course of action will know that in the event that they are found guilty, and guilty comes after a process, right, where there is proof beyond reasonable doubt, whether by your admitting it and entering a plea or it being found after a trial, and then you meet the sentence. So it is our hope that with all the examples and the reality in the society of people passing a gun to someone to say, hold it, we have also provided an avenue for them to turn it over and turn over the information and take a different path from facing the long hand of the law. But we cannot continue to have our society in this state because of these illegal firearms. Cannot.
Indeed, Minister, in fact, what we're expecting is a confidence in the process. We have a process which you always emphasize that everything goes through. What we are just laying out is sending a message that we cannot tolerate this kind of activity in the same way as we have been doing for many years. And the process will in fact set the range, but we have a mandatory minimum. Bottom line, so to speak. I have to turn off this phone, sorry. All right, we move on. We think we have covered that aspect. We go all the way to section 21, where reference is now to the, we're now moving to the Firearms Licensing Authority. There's a recommendation that section 21B should be amended to establish the Commissioner of Police as the chair of the FLA board. We have moved from that.
Yeah.
No need to comment. I don't understand the recommendation for on 222. It's proposed that the board should be, it's proposed that the section 22B should be amended to restrict the powers of the board to only make a recommendation on the issuance of a permit or license as well as revocation. What's the implication of that, sir?
Yes, so we looked at it. We weren't quite sure exactly what
it doesn't sound.
We didn't quite accept or agree with that recommendation.
Oh, well, the board has the authority
right
to make the final recommendation. So this
yes, we are empowered to make decisions on who will get the license. It also doesn't say, this recommendation doesn't say to whom should the board make that recommendation. So,
I don't want it back in the minister's office. Right. Made that very clear. Now, Minister, the lawyers are saying I don't have a right not to take action. I should, in exercising my discretion, I think I've had a flood of letters because we're changing the law, and I think I've seen it. So all the attorneys who are presenting appeal cases that are delayed have written to me to say that it's not an appropriate exercise of my discretion to see that it has to go back to the review board. And I must make a decision of rejection or acceptance. I'm thinking of just rejecting everybody.
Well, Chairman, again, it all depends on what power we are vesting in whom. Ultimately, it is, so the scheme is that an authority has been set up to, among other things, receive and consider applications for authorization to possess different categories of firearms and to do different things in relation to firearms. So the scheme provides for the giving of reasons on the processing of the application if there is a denial of the request for authorization. The criteria against which the application will be considered are clearly set out, and we have had long-ranging discussions around time frame, with a proposal emerging the last time around service standards to be prescribed to address some of the issues that the real concerns that have been raised about the experience of members of the public in their interaction with this statutory body. The scheme of the law in respect of an appeal goes up in a certain direction. The law can prescribe exactly what the powers of the minister is if the minister is factored into the appeal. I've always expressed the view, Chairman, that sometimes when we're addressing a problem, we address the wrong problem and create other problems. Sometimes when people do not do their jobs or they do their jobs improperly, we sometimes, instead of in a targeted way, address the real problem, we skirt around it because we don't want to either call out what the real problem is, whether it's the improper or corrupt exercise of powers by an individual or appearance of incompetence, whatever the many reasons are, and then we create structures around. So I can appreciate the concerns that are raised. It is going to be for us to clearly consider what powers the minister will have and settle those out, because there is judicial review of how powers are exercised, and the law is well established in case law on that. So it's really about what the policy is in respect of the role of the minister.
Thank you. No, in the law, as well, we have no dispute. I'm mentioning to you as a matter of interest that I think the law is having seen the evolving legislation from the policy, which I've articulated well. Writing to me about the outstanding cases, because we have to really clear up and establish service standards there, as you have indicated, in the FLA, so we don't have these long delays. I'm saying now a number of lawyers have seen the new law coming and are writing to me and say, I have not exercised my discretion. So they're going to move for a review by the court, which I suspect is at September. So I thought I'd mention it. It's quite a number. Just write to me that then they note my comments and saying that they should await the review panel, not the FLA board, the review, and I would not take any decision. I'll just bring to the side and say, no, I'm not entitled to do that. I should make a decision once the 90 days pass, one way or the other.
It would make sense, Chairman, because a lot of work will have to be done to restore confidence in the system. And a lot of work is being done in this new legislative framework that we're setting, so that the work doesn't end when the legislation is passed. How it is implemented and enforced will be critical, and many confidence building steps will have to be taken by all persons all over.
Yes, indeed. I suspect a number of them whether somebody is going to seek the judicial review, and it'd be interesting to see what the judges, quite frankly, I'm having interest in what the judges say in those circumstances. But we have quite a few. The delay has been horrendous. I have asked and actually provide incentives to have more meetings, but they're still at 20. We're still just leaving 2020 with appeals. So all of 21 and 22 is still awaiting results. And the authority itself has about 2,000 applications they haven't dealt with yet. Some, of course, are just, well, investigation not coming through, and the person really should be disqualified. But there will be reasons we proceed this law to ensure that the FLA, and I'm taking some steps to up to date, and we can set standards that will be realistic and acceptable to the citizen. Mr. Bush again makes suggestion in section 25, the minister to provide in writing direction to the board and approval for the use of funds. This will create a tangible record for reference purposes to promote transparency and to assist in audit processes. Current situation is that the money really outside of the expense to the board, to the authority.
Chairman, there's a backdrop that is up on the screen. Is that deliberate? A live good backdrop?
Yeah, I think that was some technical error. Live good is our social marketing team, which takes over our screen when they're going back to the thing, recommendations 25. My current understanding is that any excess funds beyond the expenses that the FLA incurs on a routine basis goes to the Ministry of Finance. If we need to use it, otherwise we have to get their permission. For example, even taking on a new office, we have to get the permission of the Ministry of Finance to so divert the funding. I don't think this suggestion bears further discussion. Section 29. Licensed firearm holders are objecting to the additional marking technically. Proposes that all firearms, we have proposed that all firearms, private or government owned, are to be brought to the affiliate of the marked affixed and the data stored. Governments at the forensic lab store them. Is viewed by these members an injustice to licensed firearm owners who are being asked to deliver their personal property to be marked in addition. In addition to that, there are already FLA stipulation that their weapons bear all the original markings of the manufacturer, including serial numbers and all other identifying marks. In order to register the firearm, the act in this section failed to mention whether there would be a fee associated with the new proposed marking system in Jamaica. We believe that this measure may impose new fees and therefore barriers to firearm ownership in Jamaica. We know new fees are involved, and we have proceeded to do this as a matter of policy. That's correct, Minister. I've acquired equipment as well.
So people who can't afford to possess a firearm, possessing firearm?
No, no, we're not adding any fees to it.
And the cost of firearms are cheap?
They're quite expensive, I must assure you, in the simplest of them.
My concern is always about the burden that you impose on persons. And yes, there is a cost, the efficiency with which persons are going to comply with the requirement. It's no secret, I feel very strongly that compliance steps should be made so that they should be easily taken. And always we have to swing the system, design the system so that it is easier to comply than to operate in breach.
This one is quite easy, Minister. Each time they go to renew their license, they have to carry the firearm in anyway. And that's accepted now. The physicals, and it's done within almost instantly.
So Chairman, I have heard, since we have been reviewing the law, a number of firearm holders have expressed the view that the operations of the FLA seem to be more a money-making venture. You pay and you get a license, which is for a certain duration, and then you have these annual things for which you have to pay fees. Many have questioned aloud whether there isn't a more cost-effective way to structure the operations of the entity to make it less fee extracting, while at the same time enabling the regulatory functions to be effectively discharged. It is an issue that is being discussed widely in many quarters among persons who are currently licensed to hold firearm.
I appreciate the comment, Minister. I've heard them myself. The biggest complaints about new appeal field, and which are accepted because there are a number of people making literally fairly, how do I describe it? There are not appeals that had any basis for appeal, really. On the other hand, those who really had good reason to look at the field put the concept a bit high, but I accepted it to see if we could get increased income to push through the backlog we have. And I'm having a series of discussion on that. You know, the review panel has to have all 3 members sitting. It is really, I guess I could use the term quasi-judicial. I'm chairman is Judge Panton. We have a former senior civil servant and a QC on board. The QC don't seem to have the time to give to it, because she's not fully retired. So we have to examine. That's part of the backlog. In terms of the regular licensing fees, it's really to run the operation of the FLA, and it is a subject of debate if they could be more efficient, but much of the clients also look for the service. For example, why have manual presence in 3 parishes, yet, you know, if they have to travel from St. Anne to Montague, they find that's an object to that. So we need to note it, because our object is to provide quality service and examine the station as it is. But I don't think we need to. The issue of marking, a national marking, we had accepted as a required policy in dealing with them. So we'll keep it there. Owners are very sensitive to anything that seems to further require them to anything with their firearm.
Like I say, Chairman, a lot of confidence building, the new machines, the laser machines, how they work, the system inside, without, of course, exposing things that should not be exposed and may thereby endanger how the regulation is done. But whatever is required, that will build confidence, because we are coming from a situation where there have been more complaints internally, externally, you know, than should
I get
be the experience.
I sometimes, you know, I seek your sympathy. In this ministry, I get more complaints about firearm and firearm license, anything including police action. But bear in mind too that the FLA board usually has long-established members of the license of the industry. In fact, the current chairman was the former president of the JRA, and the member, the other nominee of the minister, is maybe the longest trainer for juveniles, well established in the country, and runs the ski club for years upon years.
DPM, I know that you know that systems cannot depend entirely on the personalities, and it is always the hope that persons of integrity, competent persons, are in place, but the system itself must have a mechanism where people are held to account, and the process of holding to account mustn't be so burdensome that it is easier for those persons who are required to take action to just drop their hands. We have too many examples of that. And always, yes, I know you are. I know you are. These are issues that we repeatedly discuss.
Yeah. And the chairman of the Dissemination, he has the right to make recommendation, and have in fact looked at the bill himself. So we have made some deep consultation, but it's a delicate topic. We have to just keep in touch with it. Section 40, restriction on dealings in firearms and ammunition. They were dealt with the JRA. Proactive Jamaicans have comment. The recommendation of the proactive Jamaicans is that section 40 should be placed in part 2, similar to sanctions against stockpiling section. But this section is really for the, where we are now at section 40, dealing with licensed firearm, and whereas he's alluding now to prohibited weapons.
Yes.
In 6. So I think as we go forward, Minister and colleagues, Senator and member, one of the things as the law comes to the House, and when we speak and proceed to execute, is how we educate the public on the way we have structured the law.
On that note, Chairman, I believe at some point we will have to just go back through to see if there is any provision that should be of general application across the entire law. I know we have a miscellaneous section, but we may have to consider if any of the current provisions should be of general application, so there is no confusion about their applicability depending on which part of the act they fall in.
And once we have done that, we educate the public on the difference, because as I've seen it appearing on a number of occasions where they seem to mix their first section here with prohibited weapons with what is regulatory for licensed firearm holders. I'm getting instruction because draft. Thank you, Minister. The next section, we have a comment beyond. We said we went to JRA fully. Again, proactive Jamaicans who seem to be the most active here outside of the JRA. Dealing with recommendation 45, section 45 is suggested that licensed firearm not be transmuted and that they create a new offense of unlawful use of a firearm. And that where the firearm alleged to have been used in license, this offense is substituted for illegal possession. It will be less immediately damning when viewed on an arrest record again, of innocent person. In no way makes things easier for criminals for illegal possession obtains for all. Actually, illegal firearm and then event, the crime itself speaks for itself if convicted, murder, etc., and carries a harsh punishment.
So, Minister, from
the come back to the same comment the minister just outlined.
Not quite.
Go ahead, Minister.
So, Minister, we had looked at the proposal because we gave it quite a bit of thought. Our position has always been that unlawful use should really trigger an illegal possession charge. Therefore, there would be really no need for an additional offense. We know that the existing regime under the Firearms Act treats unlawful use as a basis for illegal possession. And the courts themselves have demonstrated in the Everton Lighton case, they have ventilated and opined and accepted this regime. That's it, that once your unlawful use is really legal possession. So,
Mr. Richards, my understanding though was that we were seeking to simplify. Oh, I'm so sorry. I'm so sorry, Chairman. I didn't hear you.
The question is that I see the comment here, and as you respond to Mr. Richards, I was going to expand a little bit and saying I'm seeing cases. This question of how you separate the licensed firearm holder who may commit an offense, but when found innocent, the charge was still illegal possession, and if he's charged, it's on his record. So I have some sympathy for this distinction here. So I need your comment fully on it. A charge of illegal possession is a charge of illegal possession, innocent, and therefore, as suggested by whoever is writing here, it has grave implications for the person involved, the individual. Even if they are found innocent. And the creation of a different charge looks from the technical team don't feel so, but you know, I have some sympathy for it. Maybe I just misunderstand it. So I love your full comment.
I'm just reading back. So this is the recommendation of Proactive Jamaica.
Yes, yes.
Okay, so it says that in section 45, it is suggested that licensed firearms not be transmitted.
Transmuted.
Transmuted.
Yeah, in other words, currently, if you commit an offense with the firearm, it becomes illegal possession. Right.
So, Chairman, the way the case law has developed around this issue is that a person who is licensed to hold a firearm is licensed to do so, not to commit crimes, really. So self-defense is a complete defense, and there are other things. So that the possession is not to enable you to commit crimes. And if you're a licensed firearm holder who is found guilty of using the firearm to commit an offense, then it reaches back and renders the possession illegal because you were only licensed to do lawful things. This has raised a lot of concern. So we have a lot of case law around it. It was my understanding of the policy is that we would kind of take out some of the sting out of that. And once you're licensed to hold the firearm and you commit an offense with the firearm, you would be charged for the offense, even though the firearm features in it, but that you would not be, the law is not going to reach back to render your possession illegal and then making you liable to the penalty for illegal possession. That was my understanding. Once the person has gone through the process. Minister. Right, so if that is not how it is provided for, then we need to look back at it, because this was one of the issues of tension, and in part, one of the reasons why we created a bifurcated system where we have prohibition, where the firearm would not have been lawfully obtained through the lawful trade, gone through the marking process. The holder is not authorized and so would not have gone through the vetting process to be certified fit and proper to hold the firearm. That's why we had kind of put it out. But once you have gone through that process, we can trace the firearm, because in the new system, it would have to be entered in the system marked, and the automated system would enable the ballistic signature would be taken, et cetera, et cetera. So systemically, we're now putting in something that would enable law enforcement to trace and hold to account. And once you have gone through that process, even if you commit an offense where the firearm is featured, you would be punished for the offense. Using the firearm may be an aggravating factor that could make you liable to a higher sentence, but it certainly wouldn't stretch back and render your possession of the firearm illegal, you having obtained a license previously.
But you see what they're suggesting, Minister, that we should introduce also a new offense, unlawful use of a licensed firearm. We should carry it, it should be separate from illegal use.
That would stand to reason and would fall neatly within the policy parameters, Chairman, to my mind.
The question, though, Minister, is how do we define unlawful use? And we actually battled with how to introduce it.
I know.
Because under 78, clause 78 as it is, speaks to using a firearm outside of the terms and conditions. But there might be use of the firearms out of terms and conditions won't necessarily arise to the level of unlawful use. So we would then have to carve out a particular provision that then defines what is unlawful use.
So what do the terms and conditions say about what you can properly use the firearm for? I know it specifies where you have to keep it,
right,
whether you, and matters like those. Maybe the FLA can just remind us of what the standard terms and conditions are, because you are required to use it in accordance with the terms and conditions of the user's permit or the form of authorization that you have been given. So I don't think it is so difficult, because if we know exactly what, and outside of self-defense, you know, because excessive force will render self-defense not self-defense, because the force must match the force, if I put it simply.
Now, simply examine it again, Minister. What I said, there's empathy for that. What you have explained suggests it should be too difficult, but I'd expect there's, if the person committed an offense, then the unlawful use chips in. Unlawful use is not the primary charge. He has committed an offense using a firearm, and he gets charged with its unlawful use. The court will decide if it was a substantial charge, or if it was, if he's innocent, and the charge will drop. I think what they're asking for here is that his record will not show illegal possession. It will show unlawful use.
Well, before people become so preoccupied about their record, they really must pay attention to their conduct.
Right.
And when you are, because the records flow from your conduct. I'm sorry if it sounds unsympathetic. I don't mean to be.
No, that's something you're being practical. I think your technical thing is not, but you're quite correct. Minister,
So,
that's part of what we should.
What we need everybody to understand before persons get the view that being authorized to hold a firearm and then using it other than in accordance with the terms and conditions, or using it to commit offense, is okay simply because you're authorized. Not at all. And the fact that you may be treated a little more leniently, it doesn't mean that the matter is still not serious. So, Chairman, you can deal with the issue in any of many ways, so that if you are authorized to possess the firearm and you use the firearm contrary to the terms or to commit an offense, the use of that firearm could be regarded as an aggravating factor for sentencing. And then it can have implications as to whether your license again authorized in a fresh period to hold the firearm. So it can have implication for your licensing and your continued use of it, which would be another way of saying that if you get the firearm and you use it, even though you may not get the record for illegal possession per se, you'll get a higher sentence for using it. But when it comes to your applying to have your license renewed, you may be barred from getting a renewal, depending on the circumstances. So it's not so difficult to provide for in law. And we may have to take the policy decision if we tidy up the provision, that area of the law, which says statutorily, we're going to clarify that if you hold it lawfully, you would not be charged for illegal possession, even though you may be convicted of a crime in which you use the firearm. And that use becomes an aggravating factor. But we can take the position to say that if, depending on the type of crime, of course, if you use it, that's it. It becomes an absolute bar for your getting a firearm, or you may be barred for a duration of time for reconsideration for a firearm. Something like that can be provided. So persons can understand the level of care and caution that is required in the use of the firearm once you are authorized to use it.
Again, Minister, I've indicated to the FLA that as we get this law in place, in addition to general education, that's something that should be done to analyze the firearm holder. They need not just to get this. Current thing is very superficial. You go to a range and you learn how to unload that and reload and fast in front of you, literally. There more has to be done in sensitizing a firearm holder. it need to ensure quality keep and care of the firearm. As certain as you lock down the entry of illegal firearm, and I hope as we strengthen the police force and the Coast Guard, that will happen, and ensure integrity at our ports, we are going to be criminals looking more to steal firearms.
If I may, Minister, with your permission, Mr. Chair.
Member Williams, yes?
Yes. I'm just wondering if, in relation to this matter, I'm just wondering if, in terms of the training, if we need to develop a more detailed curriculum, which may include some theory, where the trainers, well, the trainers themselves might need to be upgraded and might need to be trained, but where the trainers, instead of just taking it to a range, as you mentioned, and you unload and fire, go through you go through a theoretical aspect which addresses keep and care and the whole familiarize you with the legislation. So in other words, it would be the eventual granting of the firearm would a proper training process would presuppose would be a precondition. And maybe that would address some of the issues of keep and care, the grave responsibility that is put upon the firearm holder. I'm just wondering if we need to probably look at the whole training aspect.
I agree with you, Minister, but that would not come in the legislation. And I just spoke to the FLA about preparing a proper handbook.
Yes.
For every firearm,
the training.
Every license issued. And that would come back to what our Minister of Legal Affairs suggested before, that there has to be certain service standard imposed on the authority. And it would begin at the very front end in terms of the training they require of the individuals without corrupting the system.
Yes.
Have certified trainers and then provide them with the required handbook.
Yeah, and I'm thinking similarly, like how just an analogy here. For example, or you go about getting a driver's license. In addition to the practical aspect, there's a written test. So I'm thinking that we probably in that handbook or in the curriculum, I'm not trying to make it onerous, but at least there could be a written test. A test.
Well, you have made the point very strongly with that. I said I view that after once they award the license, they get with their license handbook.
Yes.
As a part of the service standard from the FLA, who's the authority, remind them of the salient bits of law they should always bear in mind and how they should manage the firearm. So,
yes, sir.
As I said, we have been reminded over and over that government agencies need to have service standards in dealing with the citizens. So, with this legislation come out, that will have to be part of what is looked at the FLA.
In addition to the service standards, it's also holding those who are entrusted with functions to account in a timely way and in an exemplary way, so that others who would contemplate a similar action would have to think twice, because it is time come for those who are discharging the functions of government at any level must understand that a high standard is required of them in serving the public. But to go back to the recommendation, Chairman, I would throw out for consideration that we clarify, in keeping with our policy intent, that I don't want to say we outright say you don't get charged for it, but that where a licensed firearm is used to commit an offense, then the use of that firearm may be regarded as an aggravating factor to increase the sentencing. And then using the firearm to commit an offense or contrary to the terms and conditions of the authorization would be a matter for consideration by the FLA in the relicensing of the person. And we can consider whether to bar the person, absolutely depending on the type of offense, or for a certain period of time from being further authorized to hold the firearm.
I would do it certainly, Minister, because as I said, a lot of time, well, the entire time period in settling this bill was really organizing on how to create the separation of the prohibited, the unlicensed firearm from the licensed firearm holder. Now we have the prohibited section. So I think you're perfectly right. We have to look at how we deal with the licensed firearm holder who has gone through the process. We have had some marginal cases, even people who have been quite well, retain their, takes care to manage the firearm well. In the face of challenges, sometimes we make errors.
Chair, good morning. This is
Morning.
the Legal Reform Department.
Yes.
May I make a comment?
Sure, we need legal reform.
Yes, sir. I would strongly urge us to not. The issue is if we consider creating an offense called the unlawful use of firearm, we're then going to have to look at all these laws that we have already that provide for how those offenses committed with a firearm are to be treated. When we had lengthy discussions about this issue, and we did have lengthy discussions, the MNS team of which I participated, it was a lengthy discussion, and it was felt that we would have needed more time to properly consider the implications of creating such an offense. It goes beyond just this bill. If a firearm holder acts outside of the terms of his license, over and above committing crimes with the firearm, what you can consider then is the breach of the license terms and the consequences that flow from that. But I would urge great caution in us today making a decision in respect of creating an offense of this nature. It extends far beyond this bill, sir. Thank you.
I think that is in support of what your minister has indicated. So she was suggesting we accept this proposal, and I understand fully, but we could look at how it could be, how the law, without going all what you have said, be amended to differentiate between the illegal fire, the prohibited weapon, and the licensed firearm. You heard when she suggested that maybe there could be use aggravated circumstances when the licensed firearm use was commits an offense, as well as to look at the terms and conditions for the licensing, which is what you have indicated as well. So I think my layman brain understands what you're saying. Thank both yourself and Minister for the clarification. Next combination we need to look at, I think, comes on the section along the same line. Now we go to section 47. What is here? Recommending that if you find a person a firearm and it does not have his license, system should be able to allow to find it quickly because everything is digitized and recorded.
Right. So the automation should take care of this. The operating on the digital highway. And when the NIDS is implemented, it will also.
I like that expression, Minister. It's elegant.
Well, the whole, I mean, there are gains to be had with automating your system and incorporating technology. And whether we like it or not, kicking, screaming, resisting, we are in the digital era and we are operating, on the digital highway. So,
yes. That case of that in section 47.2. This is the one where he's from the license, right? Yeah, you have a copy of that. Law 47.2. Is this the one section that he is charged? We did agree to this before.
So
You can agree to this, to change this to a fixed fine. Did
Well,
you agree to this?
Minister,
Without this firearm license, we have made that adjustment already.
so there were discussions around it, Minister, but we've looked back from the policy team as well in terms of whether or not we want to go the route of going the fixed penalty. And I'm going to give more explanation as to why. We do understand and appreciate that the firearm is not a constitutional right like some of our some other jurisdictions. It's really a privilege. When a licensed firearm holder takes up their firearm, it's a deliberate action. And I think that the message needs to be sent that if you're going to deliberately take up your firearm, you also need to deliberately take up your license to go along with it. On that disc that you get, that driver's license thing that you get, it says that you must take this, you must have this in your possession at all times whenever you have your firearm. None of us here can go to the airport with a copy of our passports. We have to treat it in that kind of way.
Yeah, well,
I think
it's a range of penalties they're concerned that.
So recall, we did say, Minister, that we need to look back at some of these penalties because this was one of the penalties that was a little bit off in terms of,
again,
it was too severe, right? So, and we've started that process of going over those penalties.
I mean, I said, we went through all of this too. The licensed firearm holder must all be aware that he has.
Right.
Yeah, that's
so
it's a responsibility.
But say you deliberately take up your firearm, you deliberately take up your license.
The penalty should not be the same as
the penalty should not be the same.
As a
so
prohibition weapon.
No, it's not. It's not. So I mean, right now it says it's 47.2, it's $5 million, and we did agree
that's
that it's too high.
That's too high.
Right. So we have gone to
I mean, I've kept my license, you know what I mean. Not my family safe, but you may leave your family one inadvertently. Yeah.
Chairman, we did propose.
Yes.
We did propose an amelioration
Yes.
to the provision. I do
Yes,
share the view
I'm free.
expressed. I do share the view expressed by CTD Richards that we have to acculturate persons who are authorized to hold firearms in a new way. And I absolutely love the example he gave. In the same way that you do not go to the airport without your passport to take a flight, or where another form of identification is required, you have to get to the place where you do not deliberately pick up a firearm without at the same time checking that you have on your person the authorization. But notwithstanding that, any of many things can happen. And we did say that we would allow a 24-hour window within which to provide the license before prosecution takes place. Bear in mind that if the holder is stopped, when the system is fully in place, he should be able to check the firearm on inspection because of the markings that are on it, or the name of the person, should be able to quickly check with the database or check in with the FLA to get the information going. And I mean, in the same way that, you know, it's going to be difficult to prescribe details for every circumstances. I keep saying, doesn't matter how many concerns we have about police officers, people are not just plucked off the street and become police officers like that. They go through a period of training. Yeah, they need to be trained a little more. Yeah, they need to be trained for a longer period and with more details. But still, I sometimes worry, Chairman, because, you know, in this age of unfiltered communication, everybody believes that all of a sudden they have expertise to do everything. And observing from the sideline, they could be the best player, the best goalkeeper, the best center forward, right? And without appreciating the dynamics when you're on court or what gets you there. You know, all these, and this is not to say, don't get me wrong, you know, that there are not legitimate concerns.
You're inspiring this morning, Minister.
No.
I like that. The best interval is on the side.
I'm telling you, they are not experiencing the dynamics of the court and the tension of other players bumping on them. They're not subject to the rules of the umpire or the referee, right? But they can produce the best play with the best results without being on court, I'm telling you. So just to wrap it up, we did say, notwithstanding where we must get, we would still provide a 24-hour window within which to produce the license before the offense is prosecuted.
May I ask a question though, Minister, before a decision is made? Because I've once again, I've said that we've kind of grappled with that and whether or not that is a potential loophole. So if it's a case where, for example, this is Minister Malabu Ford, she's licensed to carry this firearm. I have your firearm. I'm stopped by the police and the police asks me, okay, where's your license? I don't have my license. Based on what is proposed, you're gonna give me 24 hours. I have a licensed firearm, but it's not mine. It's Marlene Malabu Ford's. If the police detains the weapon.
Of course, the police can detain the weapon in those circumstances.
Right, so the police detains the weapon.
Yeah.
The person is not detained, however, the person goes away. What's gonna happen is that the police is gonna have a license. But so it's just the difficulty with operationalizing that 24-hour window. It's not the same like a driver's license or any other type of license. This to me, and I mean, this is discussions that we've had in trying to operationalize.
Mr. Richards, so I may be on my way to, say you may be on your way to a joint select committee, and in running out, you forget your license and you have the firearm on you. And hold on. Yes, man. You know, sometimes women have their handbags right beside their key and they take up the key and leave the handbag with every intention of taking up both the key and handbag. I'm just saying that we are fallible human beings and we have to draw the distinction about deliberately embarking on a certain course. And I, as a general rule, some people may be surprised to hear me say so, as a general rule, I do not believe in over-criminalizing our people. I do believe in strict accountability, all right? So providing an avenue, it's not the easiest thing. Sometimes the police may say, regardless of where you're going, we're going to have to turn you back and you go and come. The police may have to detain the person because the person has no means of identification, right? When we put the NIDS in and we pull up all the system now, you may be able to uniquely identify the persons because of the biometric information in the system. So that we may not have all of the answers on the spot as to how every scenario will play out. But let's speak at the high orienting value level. The policy is that we appreciate and accept that there may be circumstances where a person may be out without the license. And you really don't want to criminalize them. So our tendency in this jurisdiction, you know, is to treat, I'll give you an example from revenue, is to treat every dispute with the revenue as a tax cheat without appreciating that there can be legitimate dispute. And so we create the laws that makes it most punitive, interest run and compound on a daily basis. And the person who is disputing something, legitimately so, not an issue of tax evasion, legitimately so, continues to incur. And then they have no control about the pace at which those representing the government attend to their matters. So if someone gets it and it sits on their desk for 10 days, it's 10 days of compounding interest. So again, I mean, we at our level, Minister, myself, and at this level, we have to take care and see the big picture and the broad picture and all of it in our human limitations that we can see. Whereas at another level, they are just seeing it with blinkers through the very limited and strict functions that they discharge. But we operate at a high level that goes right across government, right across the society, and even sometimes extraterritorial, as our parliament is empowered to pass laws that can apply extraterritorially, says the Jamaica Independence Act.
Thank you, Minister. Right, and that's what section 48 we're referring to, right? Clarify that. 47. Right. Oh, yes, that's correct. 47-2.
Mr. Chairman.
Yes, go ahead, Minister. Member Jackson.
Please,
Coming from across the waters, tell me what's happening over there.
I won't detain you with that for now, but I could not resist saying ditto to the Minister of Legal Affairs comments just now. And suffice it to say, whichever side of the bed she slept on last night, I will speak with tonight.
I won't give you permission. I won't give you permission to inquire into that at all.
No, I am not asking. I'm only suggesting that she does.
Member Jackson, that the minister was not only accurate this morning, but elegant and everything has contributed. So
I would just say ditto with those sentiments.
So just continue to say
I'm hearing a new minister today.
Maybe, Minister Jackson, you're listening through new ears.
Indeed. See?
Well, let me say, okay, no new eyes. Okay, sorry, answer that.
Minister, as is accurate again, Mr. Jackson. We'll see what the hearing aid you got yesterday.
But
I will only close on that to say, you sleep on that side of the bed.
All right.
Okay, thank you.
Thank you. That was section 48. The last family even suggest we delete it. No, this is the area of carrying how you carry your family in a public space. And not discharging in a public place, except where outlined in section 51.
Chairman,
Member Jackson, go ahead.
I just want to insert something I raised previously, and we had a little discussion. I don't recall what the final decision is regarding the concealment. It was raised, for example, about the exposure, unintended exposure, for example, yes, and how we remove any discretion from a police officer from charging someone. If I could just be reminded of our final wording. I think there was concurrence on that concern, but I'm not mindful of the final wording to deal with that.
I don't know if you're final wording, but we do. I remember we did discuss this, that we have to give. And again, just like it did in 47 to a while ago, I have to take recognition that there could be unintentional exposure, whether it is the shirt pulled out of the waist or a skirt get blown out by the wind. Either way, should allow for the police not to be compelled to charge.
Yeah. The argument was raised, which wasn't comforting to me, about an adequate defense, right, in such a situation. And why it was not adequate for me is that we don't want to subject a law-abiding citizen to go and engage legal costs for attorney to go and justify something like that, where the exposure never contribute to anything of this at all, never endanger anybody's life, threat, or anything like that. And they have been brought before the courts. That was my major concern. But I just want to add further to that. It's a separate point. If I could be refreshed and really what is the danger if somebody wears their firearm in their waist, in a holster, for example, exposed, like our security guards do that. What is the danger with a private citizen having his firearm openly exposed?
Remember, the concern is twofold. In one sense, if it's exposed, there's almost an assumption that it could be intimidation to an individual who is seeing the exposure. Additionally, it also makes that individual a target for persons who would wish to steal that firearm.
No, but just pick up on the last one.
I think we could use it. I think, remember, we could accept the rationale for it, but I think the penalty should be, as I said, there should be a lot of flexibility in charging the person and also in what kind of penalty. So, to put them before the court. You have to ensure that they are holding them accountable, don't put a lot of innocent people before court.
It's something I raised it because I've reflected a bit on it subsequent to those discussions. And just driving on the road, even just recently, and I saw some security, one of those security companies, mobile personnel, with 2 guns in their waist. They're not police, but they are security officers, private security officers. Right? We know they are security officers. And I asked myself the question, is that endangering the ordinary citizen? They're not soldiers, not police. That's one point. The second point, if I should put my firearm or anybody in a holster, I believe, one, you are declaring that you have a firearm and you don't have any fear of the declaration. Because somebody who carry their firearm, legal firearm, openly, is saying to the other person, yes, I do have a firearm. For those who may be a threat to them, it may be a deterrent to other persons that this is a firearm holder, just the same way as a security guard that appears on a scene, not a law enforcement officer, a private security guard appears on a scene or even posted on a private property with his firearm exposed in a holster or in his waist in a non-threatening way, in the holster, in his waist. What danger, to me, it is safer to know somebody have a firearm than someone have one concealed and can use it and you don't know. So I'm trying to process those things in my mind and I can't come honestly to a conclusion as to how threatening.
I don't think it's so threatening. Essentially, you're trying to, the message in society is that all firearms must be treated with a certain level of care. And I said, I'm certain, I think keeping it concealed unless needed, I think is appropriate, but to charge him heavily for exposing it, I think is where I'm in tune with you, that should be.
Mr. Chair? Yes. Mr. Chair, Donovan here.
Yeah, go ahead, Member Williams.
Yes, on this point, as Madam Minister Ford puts it, in my view, she elegantly puts it, to choose your adjective or your adverb, that we don't want to over-criminalize, in formulating legislation. In my view, while we are trying to raise the bar and, the keep and care and the whole regulatory regime of how we conduct ourselves as firearm license, or firearm license holders conduct themselves. At the same time, in my view, we can be too extreme. My position on this, Section 48, is that you made mention earlier of a guidebook, and we spoke earlier of training and education. A licensed firearm holder, having gone through a process of training, education, having his guidebook, should be responsible enough to know that, look here, you don't go around, parading a firearm like you're a police officer in its holster. And why I'm taking this position, this is my personal position on it. As you put it, Mr. Chair, there are instances where inadvertently, your firearm can get exposed in the quickest of time. It's like the wind can blow up your shirt. Anything can happen inadvertently. It's not that you deliberately omitted, and you're charged, and you go through a process of, litigation or, trial costs. My view and my firm view is that we could take care of that. We could solve that problem through the whole process of training, education. The FLA can establish standards and take care of that matter. I don't think we should make it an offense in this manner.
So inadvertent exposure, I agree with the minister, should not be an offense. Inadvertent exposure should be, and member Jackson, and if exposed deliberately, otherwise, I said more for messaging, they keep it concealed, but if they expose it, then it should be a fixed fine or a points against them when they go for the renewal, that they go through a process as indicated of how to keep and care documentation from the FLA.
We had proposed a solution to the concern, because I'm looking back at my notes and the discussion, the concerns were aired. And so we had accepted that there are good reasons to impose a duty on the holder to conceal the firearm.
Right.
And then it would be the deliberate and without reasonable excuse exposing it, that would be the offense, and we would adjust the penalty down to really make it a misdemeanor. Minor, right? And it wouldn't, So right now,
inadvertent exposure would not be a charge. It would be deliberate exposure.
So it's a deliberate, whatever the wording, Madam CPC can find the appropriate wording, and we would also adjust down the penalty at 103. On page 103, the penalty is set out there. But we did agree that there are genuine concerns from the fact that just sitting and shifting, blowing of the breeze can cause exposure. But generally, for safety and other reasons, you would want to impose the duty to conceal the firearm when you're carrying it in a public place. Right, the public place in which you're authorized to so carry it.
Yeah, we did accept that. Minister agreed to that. So
right.
Adjustment.
So it's the adjustment in the language there. At 2, which creates the offense, and then we would dial down the penalty on conviction.
Yeah, the next section.
I would love to see the final wording on that, Chairman. I not deliberately rather than inadvertently, because inadvertently leave a lot of space for interpretation.
Right.
All right.
When we see the wording that comes in.
Yeah.
I'll accept that as a compromise.
Thank you, sir. I expect this morning the minister have your ears, so we get a compromise here. We'll proceed speedily, minister. You seem to be able to get another compromise from my colleague this morning. Next, it was 47, right? 48, yeah. Next comment comes on 51, and it relates to 48, I suspect, right? I didn't see anything here that we need to. I think we have discussed it.
My notes said we were going to be adding language at 51(1)(c) or otherwise authorized by law.
Yes. I think that's all, and that would cover what requirements. Next, the recommendation by JDF. We go all the way to 58. I think, again, proactive Jamaicans. I wonder who these are.
We had also agreed that we would review clause 52, the duty to deliver up the ammunition. So we will just await what would be presented.
Amendments, right.
Right. Yes. And I know, Madam CPC, some language was to go back to the margin in respect of 1B and also 5B.
Yes, that's right. All the words of the authority in 1B and all the words after the statement is asked in 5B.
Four and 5, we have gone through no further. We go all the way now to comments on the matrix. We go to 58. We've covered the others of 58.
Say that the specification at 57 2D about the photographs would be revised in terms of what was to be, what is set out there, right?
I think we had covered those in our own call by call, Minister, as a reminder. So we look forward to the changes. I think so from the matrix one we have to consider is 58, where the proactive Jamaica now have a long list of suggestions. So they have looked at them.
Right. We thought there was a bit too prescriptive, so we kind of thought what was here was sufficient in terms of.
I don't think we didn't have any major comments.
Save for how it was that the manufacturer's license would have been granted.
Save for?
For the manufacturer's
Yeah,
license.
the manufacturer, which we had a long discussion on.
Right.
And settled. Members, all right. They gave a
64
study. All right, we can go on 59. These are yours. We covered, there are no comments from the public. I think we covered these adequately. We go therefore to 66 where there are some public comments.
64. 64.
Straight on the original granting of license.
Something on 64 said that. And the word within 30 days after grant of a permit. That's the disposal permit. Clause 64.
Recommendation 66. This permit. There is a comment on that for the committee.
This is for the visitors permit. You're looking at 66 or 64?
66.
So recall we had not accepted the proposal for the introduction of a new permit. So in that case, what is outlined here is additional prescription on what is a visitor's permit, but we ultimately did not agree to that proposal.
Permit for people visiting the island.
Right, because they can be captured on a different
area.
Authorization.
The special member hearing is an area I have an interest beside the sports shooting fraternity. There is an emerging movie industry. It is restricted by some of the imposition of the regulations on use of firearms. So we'll have to look We leave it as is, but I'd like to say the committee members be aware. It's something we have to examine. Almost every movie shoot have to have some. They are not real firearms, incidentally. They look real and they fire projectile, I'm told, but they are so designed not to fire a deadly projectile. They reported a case recently where someone was shot at a stand. It was, I called that a concern to that. Somebody made an error. All these firearms together that they bring. Go ahead.
Just a question. So the circumstance that you're referring to now, how is that captured? How exactly is that captured in the bill?
Yeah, Mr. Richard. You said it's captured elsewhere. Where?
Special certificate.
The firearm uses special certificate. Clause 62.
62. I'm gonna say that it was clause 62 for sporting farmer users permit. Sports and I'm not sure they captured it. Well, the movie ones come get permit now to come in, but we have to look at how we make that a bit simpler.
The minister's authorization.
Yeah, it comes with the minister's authorization, so it takes a long process to get there.
But in terms of the filming of a show, if it's brought in for that purpose, it would also be captured under the special.
Yeah, that's what I'm saying. But
as opposed to having to come to the minister for authorization, you would seek authorization from the authority.
okay, it's a new building, so your old building doesn't have that.
Well, you have to do both. So.
Sorry, can I just ask you to repeat because it's not coming through clearly.
Okay, the technical team says that clause 62 covers the sporting firearms and also covers the movie firearms. And I raise this because of the movie firearms are having some challenges. And in fact, it is viewed as one of the hindrance to expanding the filming in Jamaica. There are a number of people find that Jamaica is an attractive site, but the permission process is too tedious. And they have been rebuilding Jamaican villages between Puerto Rico and Barbados.
This is one case, DPM, and I'd be curious to know if in addressing that issue, we have any data on how many applications have been made, how long they have taken to grant, and what were the issues. I don't know if there's any stock taking of that in that regard. But I find generally, that while accepting that processes are tedious and matters linger on desks for way too long, I sometimes get the impression that there is such an impatience with process, and even due process is confused for unhealthy bureaucracy. So I don't know, and this is again where there is almost it's almost fashionable to just speak about anything that requires going through a process as a problem. And no doubt it is because of the real challenges faced in interacting with the government in so many areas. But I don't know, is it really the case? Because I find in issues, we tend to almost tremble once we hear the withholding of investment because government is either too slow or not doing something that persons want to do. And I'm just not aware of the data. I'm not saying that there is no concern, just to assess the extent of it and then what would be an appropriate solution to those concerns.
That line of thinking is perfect, Minister. I think 62 applies to the sports users and that don't need any modification as well done. The concern is really the firearm used in movies are not firearms designed to be fatal. They're actually perfect replicas. But
and we do have a case of I think Mr. Baldwin being tried for discharging a firearm from which someone died. So while it may not be general, we do have examples.
You brought a real firearm in, so you have to certify that the one they're bringing in. I was told.
Some of them are not replicas, Minister. Some of them are actually real firearms, which we've seen.
They don't come under the regular permits, but most of them are not.
Most are replicas.
Right. About 2 movies recently Minister. I think the James Bond movie, which took a little roundabout to get set, is the first one we had for a long time. And we did approve those. And you have one being done now, which, but I think, again, I said the timing, I'm not saying that we could get the analysis of the timing it takes when they apply, because they do plan these movies ahead of time and they should send it. But
so when we come to you,
you look at it and advise the committee, Minister.
Right, when we come to you though is because of the type of weapons. So recall that the authority can only grant licenses for permits for certain types of weapons. Everything else is administration.
Yeah, I think the non-lethal weapons actually a little bit more complicated, Minister. That's correct. They have to come to the minister for approval. If they doesn't give approval for non-lethal weapons, imitation guns, etc. But we can look at a process. What I'm looking at a process whereby the approved companies and if the weapons are proven non-lethal, once the police are aware and approve it, we could let them in. We don't have to go to the process to come through the various steps, which is necessary if you're going to the minister. But I will not delay the bill for this one, Minister.
Okay, Chairman.
If I could ask another question. So under 62, that certificate applicable to shooting ranges, gun clubs, etc., would permit such a group to use that authorization in what way? So for instance, the shooting range would be permitted to have persons utilize weapons under that authorization at the shooting range?
Yeah.
It's unclear to me specifically what we would be authorizing the group or person to do. So the group possesses a firearm. Who specifically can use that firearm on the range?
This was designed to cover, and I'll have to deal with the technical thing I have to explain and the legal minds. But
If it is, Chairman, that it is really subject to the
broke a little bit here. It is the idea is to give the sporting gun rifle shooters an opportunity to bring the firearms in and use at a particular range in a particular competition. And they can practice at a particular range as well. If it is not clear, then but that was the purpose of it, Senator.
I'm actually not saying that it is.
I have a question, but I'll answer.
There, it is that it's not specified.
Oh, it's not clear enough.
I just wanted to know.
So
yes, I just wanted to know, is it that the specifications will fall at the time of the authorization and I guess subject then to the discretion of the FLA, or ought that to be something that we specify? That's really my question.
Okay.
I'm not sure I quite understand.
I think what's that? The way it's suggested, who specified the areas for its use and who?
So
the FLA should.
Authority, right?
The authority senator. Mm-hmm. So when they get their permit, it will say they're coming in the last date for a particular competition to be held at DRA or at Twickenham Park, right, and allowed to. And
the certificate is specified for a specific period at a specific place,
right?
As it says on Section 2.
So therefore, so would this cover then the training portion of it?
Yeah, they'll have to use the approved range as well. Usually they come, they go straight shoot. They'll have to use the approved ranges.
I'm not talking DPM about the shooting competition. I'm talking so I understand that there are activities where they're training youngsters. Would they fall under such a special certificate?
But where would the training be held?
No,
either a shooting range or
the range. At the range, yes.
Partners coming to be training youngsters, or the training of youngsters is a different permit, which we had agreed to already for the 12-year-olds and up. But this is for particular individuals coming in the country to participate in particular events.
So my question, DPN, what I understand the mechanism of that training to be is that youngsters who are coming onto the range in these devised programs are not necessarily youngsters who have a user's permit for their father's or uncle or grandfather's weapon. So they're using weapons that are held by the range authority. And so they come on. What license covers them from coming on and being trained on the range? That's my question.
A little bit of them. The shotgun trainers which are trained here, there is a request that this be included in trainers, but I said the 62 trainers permit, but 62 is specifically designed for individuals coming to Jamaica to participate in a competition.
That's one subset.
That's the primary subset to deal with here.
But it doesn't specify that in a DPM as I read it.
There's of course, use of the farm at the athletic meet with the farmers.
Perhaps
to me,
we could just look at the categories set out at 57.1 and then say which of those categories it falls under. Mr. Richards, in answering Senator Golden Campbell.
So, Minister, the firearm use as restricted license could be utilized for the purpose of the training for the individual who is going to train, because the firearm use as restricted license allows that individual to possess and use in a specific locale, and that locale would be a shooting range or a gun club.
I see. I see.
Right. Thank you.
All right.
And that's different from the trainer's license.
That's different from the trainer's license. The trainer's license for the individual who is actually doing the training and not receiving the benefits of the training.
Okay.
All right.
Okay. Thank you.
All right. We have gone through this, so the next comment from the public comes at 66. I don't think we had any challenge with their comments there. We didn't accept their comments. That's also some they had to with permits.
Sorry, Chairman. I'm sorry to interrupt and to go back, but I do want to raise a concern in relation to sections 52 and 54 and the concerns highlighted by the JDF, because I do see a potential conflict in relation to the ability to charge for illegal possession when you read sections 52 and 54. So sections 52 and 54 are essentially allowing persons who come into possession, allowing persons who are not authorized to possess a firearm. If they come into possession of the firearm, it essentially allows them time to report it or to bring it in, right? So I'm wondering how that is going to interplay with the ability now to charge someone for possession, illegal possession of a firearm, because the police will find you, you have the firearm, you do not have an authorization to have a firearm. So that's a prima facie case of being in illegal possession of a firearm. However, as the JDF has highlighted, the person with the provisions of 52 and 54, the person would not be at liberty to argue that, oh, okay, I found it and the 5 days have not passed yet, so I shouldn't be charged. So I think it's something that we need to look back on and see if there is any potential loophole.
So through you, Chair, we did mark 52 for review, Ms. White.
Right, but I don't
and
know.
among those, it would be
was,
reconciling. Yes, I understand the point. Yes, so
right,
that issue would have to be reconciled.
Right.
So this is by the committee, it's clause by clause.
Right, but I was just highlighting that specific issue. I don't think it was.
It's a good point that has to be taken into consideration in reviewing it. Yes.
Go back, then we go then back to clause 66, authorization. Any issue there, Mr. Richards?
No, I thought you said it was, accept that.
Questions?
Oh, 66 was in relation to the changing of the barrel. And we had looked at that and we thought that, right, the change of the barrel really also changes the ballistic signature of the weapon. And this would, of course, pose a challenge with respect to tracing. Any kind of modification, we did agree, should be approved by the authority.
Yeah.
Right. So we're not accepting that from our standpoint.
66, form of firearm authorization.
Sorry, I thought it was 66.2.
66.5, solicitor subsection 5C shall be able to allow for any guest or license to be in possession of and use that licensed firearm on the direct and constant supervision of the license for the purpose of training in firearm safety and operation or introduction to training or shooting sports.
So, Minister,
Right.
the ministry's policy is that including such a provision would create a potential loophole where persons who may not be deemed unfit to use a firearm would be able to use it without the supervision or the intervention of the authority. Anybody who's in possession should be subject to authorization coming from the authority. So that proposal was not accepted.
Training or son without the license or permit. So 67. This is really, what is this about, Minister? Again, authorization. These are the standard things, nothing yet dispute.
The Article 67 is a recommendation coming from the Jamaica Defense Force that certain applications to the minister we should provide that certain applications
be approved by the COP.
on the recommendation of the.
Well, that's what happened though.
Yeah, I'm not sure that it's a valid.
JDF,
so JDF persons were actually making the recommendation.
The police approved everything that comes to me first. Commissioner of Police.
Right. Well, not JDF. So, I mean, the JDF makes the application to the minister for authorization for them to do what they want. Yeah. The JCF makes their approval to the application to the minister. Yeah. So the specific entity will make the application to the minister. So each entity.
They're pretty routine. And for things that are transit and so forth, we get approval from both of them.
Right.
That's what exists now. Clause 71, renewal. Delete unfit, proactive Jamaicans. Technical team, any comment for committee? We had been through this already to find any. We didn't have any notes on that, Minister. I don't recall this challenges to this section.
No, it's not one of those flagged by.
Yeah, I don't recall the flag for this. So go on. Clause 72, amendment of terms and conditions of firearm authorization. Again, I don't recall any.
Nothing flagged there.
73, registration of firearm.
I have 73.3 flagged to be revisited, and we reference 58.3 or 4.
You refer to 73.
3. And we also have 5 to provide for a grace period at 5. 73.5, that is.
So I have to raise our concern again, Minister, about how we are treating with some of these matters relating to firearms. In our discussions with the authority, one of the things that has been pointed out is that there were some 10,000 license holders who didn't come in every year to register. And that posed a challenge in terms of trying to find out, in terms of traceability and having a good handle on how many license holders there are. So the requirement to register is something that really and truly we don't want to kind of just bypass it as something which is not very important. It is really quite important.
No, I don't think that's a suggestion.
Right, but the suggestion, Minister, was for there to be introduced a fixed penalty. We have discussed with FLA as well.
You give a grace period of what, about 10, 15 days. The birthday you're going out to register.
There's a birthday you're going, so I'm not sure what is so difficult. Nobody forgets.
No, but
to
still think
to realize when you have to renew your driver's license.
No, it can't slip by. I missed my driver's license.
Yes, but that a driver's license is not a firearm. I think that we're sending the wrong message respectfully.
No, I don't think it's a message. The message here is strong. If there's a fixed fine for failure to register. But if you give a 2-week period of grace to remind people, they might be traveling. Can happen in today's world. Somebody can be off for 6 weeks during their birthday for good reason. You can just be extremely busy.
Chairman, I agree. I agree with CTD Richards about the care that has to be taken in sending the signal. Bear in mind, though, that when a person is licensed to hold the firearm, the yearly collection money collection process, among other things, does not render the holder unlicensed. I do agree, though, that if persons do not honor the time frame, then it can impact the efficiency with which the authority serves the public.
Yes, so there should be
if everybody comes in late and then they scramble around, but just bear in mind that you're licensed for a period. The registration and the licensing is not the same thing.
Right.
And I really wonder, Chairman, notwithstanding the revenue implications, and precisely because of the revenue implication, because what is gain to one and the other side is a take from the other side. Whether it is, given the number of license and various forms of authorization issued, how many are currently in existence, whether we're not making it unnecessarily burdensome merely because of the revenue to be asking people to come in every year when their license lasts for 5 years. I just wonder aloud. Because you see, sometimes we write in things without sufficiently thinking about what it means to administer. It's like, every meeting you must have a reporting requirement, and that becomes imposed on you. Who's going to collect the data? Who's going to draft the report, review it, finalize it, and ensure that it is submitted on time? So in one breath, it sounds really good. Of course, we want the reports, but the process that goes into providing a report with proper data that you can disaggregate, right? Not useless data that just drop in all kinds of things, and sometimes you're reading what is submitted as a final report as a draft. What really is the necessity? I've been convinced of the recertification, etc. But does it have to be done annually when your license lasts 5 years? Or is it really primarily a revenue making activity, and then we start justifying it for other reasons? I don't know. I'm just wondering, because it's a legitimate question that we must consider. And know that we are talking about this part of it, the inspection. Again, it's not that you are unlicensed or without certification here. So considering the signal that has to be sent, you have to consider that against the type of activity and how it relates to you're already being licensed if the license has not been expired.
May I suggest, Minister, that
it's my minister, but I consider, I think the point raised by the minister, the annual realize, well, it's good to remind the people, but I don't know if it's really that. You just
I was going
you
to
have to maintain the institution to do the requisite inspection and so forth. So there's a revenue component, but you need to do it every year.
So I think we should shy away from thinking of it as a revenue generating.
No, I agree.
Thing.
In fact, the institution need to be funded.
Okay,
That's
so correct, Minister. And think about it.
Leaseholders have to fund it.
Right. And
What I'm saying is, all right, suppose the leaseholder want to buy a 3-year permit.
your duration license is 5 years. It's like
Yeah,
coming
right.
every year.
No, we have to research by them after, I think, every 5 years.
Right.
Which means they go and they get another test and they go to the range and get checked out. But why couldn't, which is one process. Why couldn't the leaseholder say, all right, we charge them $10,000, I think, for a pistol. I don't know what it is. So, okay.
So, Chair,
Go ahead,
Before
go
you
ahead.
come,
now I have a question, just a question on that point. If I am permitted to.
Sure, sure.
Is there any other utility, any other objective that the 1-year recertification registration process is aimed at achieving? Let's say, for example, is there any law enforcement, any investigatory aspect of that you coming in within the year could assist if there's any underlying investigation other than just the revenue component? Is there any other benefit to the registration annually? I mean, from, other than,
Right. So
before that question is answered,
Minister.
Chairman, are you finished, Member William? Sorry, I don't mean to interrupt you.
My apologies, Madam.
No. Your point is a proper point. I just want to ask DPM, and when I ask you, of course, I'm throwing it out to the team through you. We have a model here, and again, I will use an example from another area. We design projects, we allocate a project sum, and then most of the money goes towards administrative expense. And what is left for the actual work to be done becomes limited. So it's whether the payment of the consultants, et cetera, important as they are. And I know you will relate to DPM because these are issues that we discuss around some of the intervention measures all the time as we been assessing, what has been normalized in the jurisdiction. But what I'm saying is that, so I do accept as legitimate the importance of having the revenue to discharge the functions that the FLA perform. Everybody wants service and very few are prepared to pay the fees for the service, forgetting that it does take cash to care. So we want all kinds of things.
You're campaigning there, Minister? I thought you're not.
No, Chairman. This law requires deep analysis, and you and I, more than anybody else, knows how long we have spent working on this and all of the other things that people sometimes don't appreciate how much time we actually spend analyzing the matter to come up with workable solutions. Because everything is not done in the glare of the camera. They sometimes assume that we're just twiddling our thumbs. Many times we're up all night into the wee hours of the morning, doing the work, but not to divert away from the point. So accepting that the revenue earning is important to enable the authority to function. Some things you can do less of and free up your time to do more of other things. So that the annual recertification, it's timely. And if a great part of the justification is that because it has to be done, you need the revenue to come in to do it. If you don't have to do it with that frequency, then you can actually focus on some other aspect of the regulation of firearms that will allow you to achieve the goals probably even better. We just can't lock ourselves into thing and make it more cumbersome for people every year. It's a whole lot of things government needs to do and people need to do. And we don't have to increase the frequency with which they interact with the government to achieve the good governance goals that we need.
Yes, and
yeah, but member,
Oh.
minister and member, I think the point is saying, you know, because I'd ask for the technical team come back in that you could look at a person who's willing to pay for 3 years and allow him 3 years to re-register.
Okay. Yeah.
Doesn't mean you can't monitor whether that person has committed an offense, whether it's been featured.
No, that's
you
what
can't
I'm
be
saying, Minister,
lazing
no.
with. Yes.
Minister, sorry, Judge. The minister, you know, you're perfectly right. I'm saying we have, you see, what I'm looking at, we have taken care to separate the prohibited weapon, which is the criminal possession, from the license holder. We still have to give the license holder a strong regime to send a message of the weight of the burden of carrying a firearm. But if he licensed for 3 years, the re-registration every 5 years, but he's willing to pay for 3 years, why not allow him to pay for 3 years? In fact, give him a discount, because if you have the money up front, you earn interest.
Can I ask a question, Minister? Do we license our cars for 3 years? Or do we license?
Mr. Richards.
No, sorry, Minister. I just need to make that point because I'm a little concerned that because every year you have to renew your license and renew your fitness certificate.
A car is a fitness certificate.
A car and a weapon. So remember, what I was trying to say earlier was that look at it outside of the revenue generation. The registration each year, the authority would inspect the weapon to ensure that it's still in good working condition, and also the amount of ammunition that you have received or utilized for the year, and whether or not you're still a fit and proper person. So it's several things outside of just paying money to register for the entire. The authority inspects.
Member Williams, Minister, come back in. Hello, Member Williams, Minister. You have to put it all together for us. Member Williams.
No, I was saying the responses just now really answer my query, because I wanted to know, outside of the revenue generating aspect, you know, what are the other beneficiary or other objectives that the FLA seeks to achieve? And you know, just now that has clarified it for me. On that basis, I would support the 1 year annual registration.
Outside of that as well, Minister, the author can inspect to see whether or not it have modified the weapon that you actually authorized.
I hear you know that. I think the question raised by the minister is still very relevant. We do these things.
Yeah.
We have to always ask, why do we do it, and does it make sense? And you know, government should only do what, quite frankly, since I'm on the council, that what they are required, what is necessary to be done. And you have given some reasons for that, but it's a relevant thing, you know. Why can't allow them to follow
Chairman,
Sure,
there was a time when my work was a little more far removed from the day-to-day lived experience of the people. But the interesting and powerful thing about a democracy, where you come to high decision-making seats through the vote of the people, and a process where you have to go in the nooks and crannies and the hills and valleys and meet with the people and see how they live and gain a deeper understanding of how government impacts them, you know, to enable us to pass the laws for peace, order, and good government. We hear of the delays sometimes in completing cases. It may not exactly apply to the FLA, but let me make the example anyway. So these activities, of the many things that the FLA need to do, how much of its time and resources need to go into which set of activities to enable us to achieve the goal of properly regulating the firearms industry? And then we have cases where the formal justice system has been engaged. We have the concerns about the delay it takes in completing cases. My preference is to lean towards the time allocated and the resources allocated to the frequency of activities around some other activities instead of this annual thing of coming in when the license is for a greater period. Because, we have a deep vetting process that you're putting people through. Let's not invest so much into a new system and then the rest of it is just as tedious and cumbersome. So we are going into deep vetting of people before we authorize them. We're putting in a more sophisticated system of tracing the firearm, taking the ballistic signature, adding marks to it. We're automating a system. We go across government now where we're putting in the national identification system, and those who opt in are going to be served a little quicker and a little better and a little more accurately. And yet we want to maintain other parts of the system as if we are not having the benefits of the improvements. And this for me is what puzzles me about the design of systems and puzzles me as I do my deep analysis of our governance issues and in particular of what is required to make government more efficient. So this may be just an example of it, but we have to balance out how we allocate or how we assign functions and what time and resources would be required. Because ultimately, what goals are we seeking to achieve? And we have culturalized our institutions to be so bureaucratic, majoring in the minor and minoring in the major. And then we talk about automating it, and then we become as laborious as it is. I'm sorry. I am not put into this position to not constantly review things, constantly review how we do things to make sure that government is more efficient and that it is more responsive and accountable to the people. Below us, some persons may have the luxury of just maintaining a position for government for the sake of maintaining it. We who serve in the way that we serve at the level do not have that luxury. And constantly we're going to have to challenge the thinking, push new boundaries. So always I would say, if the activity is not critical, don't have citizens coming in. If there's an easier way of doing it, balance out the thing, man, realign it.
No, the general comment is very relevant, and I think that's what you have to. Each regulation was reviewed in that context.
So I am suggesting that we respond by also providing the grace period of 30 days after the date. We have it that they can bring it in 30 days before and 30 days after.
Yeah, we have to
and thereafter, anybody who is delinquent, FLA must take note the explanation they give, whether it becomes a repeated explanation, and so you can't really accept it because there's no pattern. If it's a pattern, and then determine whether that person remains fit and proper.
Yeah, that's fine, Minister. I think that's an appropriate way to do this. I'm with you on that completely. The next section that with questions from our matrix, section all the way up to section 80, we have gone through this callback already. We didn't make, I think we had a couple, I don't know if we had a red flag raising them, but I don't recall any. Further, there's question, but the public has raised an issue with 83.
What is the issue that has been raised? 83.
They are questioning when complaints are made that are not substantiated. Usually, the domestic person quarrels, the girlfriend will complain the boyfriend and then withdraw this the comment. I'm not sure They're suggesting as a result of a substantiated that they want the word substantiated included in the complaint, I think. 83, let me read it.
83.1.
83.1?
83.1B.
Yeah.
So they're recommending that we replace what is in the provision now with what they have here. So it would read,
as a result of a substantiated complaint made in circumstances where an arrest has been made or is imminent, as opposed to as a result of a complaint made in respect of the holder of the authorization. In other words, currently, if the friend or spouse or complain to the authority, they can in fact act and withhold your license. They are suggesting that this should be more explicit by suggesting that the language used should be more specific. So as a result of a substantiated complaint.
What clause is this?
83.1B. Suspension of a firearm authorization. It's one that has to do with domestic disagreements. I hope we can use our domestic violence centers to reduce this.
Well, again, DPM, I appreciate the concerns, and we know that emotions run deep and irrationally, and sometimes is one word against the next. Behind closed doors, many things happen. Sometimes there are no eyewitnesses. And true, the law in its wisdom considers that people may be motivated by any of many things. But I think we just have to consider the really high level of domestic violence that we have in the country. And, so how you substantiate a complaint if there are no witnesses, it's one word against the other.
Yeah,
I mean, I do accept and understand that people can do things in the heat of the moment, and we have many examples of malice motivating people to take action. And we also have examples where fear motivates people also to recant, threats, all kinds of things. But what is not in dispute is the high level of violence which exists in the domestic context. And sometimes I think even the use of domestic may water down the brutality of the violence meted out in intimate circumstances where people are to love and care for each other. And somehow we think, oh, it's just a domestic thing. We see it in complaints made about how these are treated when formal reports are made. Oh, and not just man and woman thing, right?
No, this is, Minister, you are on a track which I like, which I have spoken to on many occasions. This is why we have been, the Commissioner have been busy working with international to set up the domestic violence centers, redesign my reception area, the police, the whole front office of the police stations, because domestic violence is a problem. And I've been advised on this. I said it is.
Let's leave it, and when we debate in the House, we see what's made of it.
All right.
Because I mean, I would expect that the board, this is not that the board shall do it. It's a discretionary power that is given to the board. And the board members are not drawn without consideration for their fitness to comprise the board and discharge the functions of office.
Include a high court judge, retired high court judge.
So
I'm with you, Minister, because it will be, let me say, even one step we make, we leave him with the firearm and him shoot the person the next week because it was substantiated or it was not take the level. Substantiated essentially means evidence.
I rather we err on the side of caution in this kind of case than to say, if me did know, as Jamaicans say.
Yeah.
But you pull it away, at least you take away the opportunity for its use.
Indeed.
May I, DPM,
Sure.
if I could offer, and I've heard what Minister Malahoo Fort has said. I agree largely with the points she's making, but I do also agree that as a result of a complaint is rather vague in relation to the nature of the complaint. And while if it is intended that it cover complaints that arise in a domestic situation where domestic violence is threatened, would it be useful to have some language that said as a result of a complaint made in respect of the holder of the authorization that the firearm is being used or has been used or is being threatened to be used for some purpose contrary to its license? Is that language a little bit more? Because when you say complaint, if someone comes in and complains that there's been a domestic issue in which the firearm is not implicated, and there's no complaint that the firearm use is threatened, is that complaint sufficient to cause the board to act?
I agree with you, Senator Golding, through you, Chair. The complaint ought to relate to either the threatened or actual use of the firearm in question by the holder.
Through you, Chair. The complaint, it is proposed that the complaint should be in relation to the individual's fitness to hold the firearm and not necessarily as to his use of the firearm. Because if the consideration in the granting of the firearm in the first place is as to his fitness, then that should also be the consideration as to the suspension of the firearm. So maybe agreed
too. So it can, right.
So I think the comments that Mr. Bailey is valuable. As I said, it's a delicate one, and I tend to be the best to be on the to err on the side of caution, because, but yes, if the man start beating up he's have a regular habit of using a button to beat up his son, and he has a firearm and he gets to call his wife every word, and he might switch from the button to a firearm. But the point made by Senator Golding must be ignored either. But let's just debate it and then see how it goes. Because,
right, Chairman. So I was just saying that the complaint, I did not agree with qualifying the complaint about substantiated complaint because of the difficulty in that context. But I do agree with relating the complaint to either the threatened use, actual use, and the fitness of the holder to continue to hold the firearm.
Yeah, the one who is willing to use physical force to restrain or to get his way with his family or anybody.
So it means that if it is that we connect the complaint to his fitness, it would also capture situations where the individual, for example, would have used or threatened to use the firearm, because fitness,
yes,
as it is,
when he's drunk, he keeps threatening.
Intemperate habits.
Well, essential. We keep it calm there when you look at the language that can ensure you recognize, taking the consideration all those features.
But you may have a one-off situation, and I think perhaps that is where the complaint, the concern about what kind of complaint and what else should the law specify qualifying the complaint. As unfortunate as a one-off threat or use of it, depending on what is happening, that one may not be able to substantiate. It may be an entirely different situation from a pattern of behavior, which brings into question whether the person remains fit and proper to continue to be authorized to lawfully hold the firearm. So I don't think that just limiting it to the fitness, because if you inquire upon an investigation as to fitness, it may lead to the person being entirely barred from holding the firearm in the future. Whereas you may have a less stringent response, but equally important. I guess is the issue of proportionality is what I'm referring to. But we can consider, I know the CPC, once the instruction is clear and we're benefiting from the discussion, and we accept the recommendation that the complaint must relate to the use of the firearm and the fitness.
Potential use of the firearm.
Use or potential use, and then whether the person remains fit and proper to be entrusted with it, we can address the concern raised.
The points are valid. We'll look at. Please look at it.
Chair,
Of course, as I said, there's a process of appeal as well. Sorry, was that CPC?
Chair, just if it helps, I think this provision had been originally worded to tie to a complaint made in respect of authorization. So it would have been less personal to the complainant, but more in terms of whether the authorization is proper.
Yeah. Thank you, CP. And Minister, bear in mind, as you always remind us, there's a process involved. So if there's a single complaint that could have serious implication, even if the firearm is repossessed for the time, they can go to the appeals panel, which is the structure of the appeal panel is it's pretty robust from a judicial point of view.
We could ask the CPC to just consider, in light of her intervention, and also having the benefit of hearing the issues raised, an appropriate rewording for consideration by the committee and recommendation to Parliament.
Yeah. No, sir, let CPC proceed. The next section that raised some issues, we had 84, we are going to 84, and that has about some contribution again from the Jamaicans technical team. Any comments on that? A long comment.
84 had to do with revocation. We thought the provision as was drafted was fairly clear, save for we wanted to clarify the additional grounds for revocation, to also include, I think this came up at the previous meeting, to include conviction for a drug offense, drug-related offense, or for a defendant of 4 more years was imposed as a child.
Yeah.
Right.
Their first complaint, I don't think we can change. They were asking the word intemperate habits to be removed.
No.
We can't do that. It is a little bit subjective, but it's something we have to maintain. We had gone through this. I think we had debated this quite extensively as well in our section by section.
Right, no, we had agreed to some amendments to the provision.
Some things were flagged, which is being done. I don't think we need to pursue the proactive rationale too much. Section 87, appeal to minister has been removed. Section 87.
We worked out that scheme now. We have worked out the scheme internally, so we'll issue the instructions, right, to the CPC accordingly.
Yeah, that's what we're discussing at the very beginning.
Right. So based on the direction of candidates, we would be using the.
Yeah. We'll have to sort out the review panel, current status, standard of service. We can't have them waiting 2 years to get an appeal. It's not legislature committee members, but we'll have to ensure that we can follow the regime and get their reviews done in reasonable time. That was what, 87.
90.
This is appeal. Right.
They had proposed to insert reason suspects that any prohibited firearm or ammunition is aboard of conveyance.
What does this really mean for customs and practice? For the search and the seize? Just explain for me.
So customs, when customs
came in them.
Right.
We accepted some of their proposals.
We accepted some of their proposals. We didn't accept this one in relation to the power of the customs officer, because the general view of the committee was that it must reside under the Customs Act in terms of their power of search and seizure. In respect of Proactive Jamaica, we wanted to insert reason suspects that any prohibited firearm and ammunition is on board conveyance. Recall how we have done the scheme of legislation. Prohibited weapons are on part 2. So I'm not sure. I'm not quite sure what this recommendation was seeking.
It doesn't make much sense. We have to keep prohibited in there because the found that we don't need to put prohibited in there. Right. Second phase is 92. Power search and fire is more relevant in terms of customs officer acting in front of the Customs Act. Should we insert that?
No.
Website, this is another thing that website should really be always under their legislation, as opposed to being included in fact.
Sorry, Mr. Chair, before we move on from 92, in terms of the circumstances in which the conveyance or premises can be searched, I know that now it says that it's where the conveyance or premises is being used or has been used, and we would submit that the likely to be used should also be included. Or 92. Is 92?
You mean it's about to be used as opposed to likely to be?
Has been used.
Being used, has been used, or is likely to be used, or about to be used. Yeah. I think that's the about to be used. Yes.
Draw with that. 94. About to be used, driving down the road. So we have to be with it. Section 90. Next section for comments we had on the matrix is 94. Powers of a constable in respect of concealed firearm. I think that adjust here. I don't think we had to be adjust. Ask question, and if you have read to search, you search. That case, that famous contract case, Miss White, they had to search. And a law officer who had his family license, and they still search. And for the illegal weapon.
Don't forget, Minister, this recommendation is supposed to include the words prohibited for that would be limiting the provision. It's not necessary. So it's not
Section
not acceptable.
95, retention of firearm and ammunition. Turn off the firearm weapon. Oh.
So they were just proposing to include a timeline within which the firearms were returned. We have no disagreement with that proposal. The only
5 days is too short.
5 days too short, so we're proposing 7 days instead.
14 days
14 days.
in Jamaica.
14 days might be unreasonably long, but we go ahead. 14 days.
If you take the firearm, you must have good intent to man firearm. So I give him 10 days. That's my reason. And if the man's at risk, you return the firearm, or he'll be charged with contributing to conspiracy. Section 97.
Which one is that, DPM? The 7 days?
The question of when where no legal procedure have been instituted against the person in respect of any offense mentioned in subsection 2, and you have taken the firearm or ammunition from the individual, you need to return it within a given time. Currently, there was no time limit on it.
I was just asking for the clause. Just remind me which clause was that?
90.
95
Oh,
minutes.
got you. I'm right there. Yes.
Right. It's suggested 5 days. I'm suggesting 14 days. But there must be a time limit. You can't just take the man firearm and ammunition. Don't charge him and have it sitting down for 3-4 months.
We're suggesting 14 days.
Oh, too bad. Technically, you were saying 7. The citizens have said 5 days. I think that to see the farm in the first place, there must be reasonable grounds so to do. That giving them time to do the research. Be a charge. Or we want to treat it like
14 days. I'll go with that.
okay. Next comment really comes on to section 97. We didn't have anything flagged in 96.
Sorry, Chairman, before you move on, just going back to 95, the proposal was to include a provision for 14 days in 95.4. But in 95.2, the 95.2 allows for the retention for so long as it's necessary for the purposes of an investigation. And a proposal had been made during the earlier deliberations to include the word reasonably before necessary. So this creates a difficulty now in terms of when this is to run then.
Yeah,
if it's to be retained for so long as is necessary for the purposes of an investigation,
okay.
And then where the retention is to be continued, where the investigation results in legal proceedings against the person.
So that would go back into 4 then, apply to 4.
But it would still be open-ended because the officer
yes,
being empowered to retain the firearm for so long as may be reasonably necessary for the purposes of an investigation. So at what point does it move from no longer being reasonably necessary for the purposes of the investigation?
Thank you, CPC.
Ms. Grant,
Right.
the proposal will be maybe to amend the subsection 4. So it says where no legal proceedings or it is determined that the firearm is not necessary for the purpose of investigation, and then there's an obligation to return it.
Yeah.
So both criteria would have to be satisfied.
Yes, but then how long would it take the person to the officer to determine that it's no longer necessary for the investigation? The time that still leaves an indefinite period of time.
Yeah, we could not reasonably prescribe a time because the investigation could take. But I believe in terms of the obligation to return it, it must be upon the determination that it is no longer necessary. But we can't at this point prescribe a time for the investigation.
I'm thinking about other innovations to come where we do recognize that it is in the context, in the peculiar context or the context of the peculiar Jamaican situation, where so much challenges have been experienced investigating matters, and the real need to allow time to investigate. We're looking to giving a time frame where you can't really tie up people, as it were, if your investigation is not going to yield a charge within a time frame. The question of always what is reasonable given the many challenges that are in this Jamaican context remains a real one. But once you can have persons under surveillance for any long period of time, but once you're going to formally bring them in and engage them, we really do have to look at an outer band to say, if you're not yielding a charge, say even within a year, long as that sounds, but the fact of specifying a time, an outer band, is still better than open-ended. Just so that we've had too many examples of things being taken from people under the guise of an investigation or for purposes which may start out as legitimate investigation, and then somebody forgets that the matter is lingering or other things take over, and it becomes a permanently temporary situation. So DPM, I'm really just saying that while while it's the norm to speak to what is reasonably necessary, time frame as being reasonably necessary to achieve an outcome. If your investigation is not allowing you to bring a charge within a certain time, you're really going to have to, I don't want to use free up, but you really have to go into shift gears. In how you're going to just hold on to someone. There is a firearm, you may say that if the firearm is featured in an offense, you would be able to, you'd have the ballistic signature, etc., etc. So the question that may arise until the person is brought in is whether you want to continue to entrust the person with an authorization to lawfully hold the firearm. But while I appreciate the need for time to allow the security forces to do their work, once the formal system is engaged, I lean against open-endedness. Or I'm in favor of specifying time frame and then renewing if need be, just to see. So right now, 95 says, where a person is arrested for an offense under the Act, any firearm or ammunition found upon the person at the time of the arrest or at the time of the person's alleged commission of the offense shall be retained by the police until such time as the person is released or legal proceedings against the person in respect of such contravention are finally disposed of. Fine. A constable who takes possession of any firearm or ammunition to pursuant to any power under this Act in relation to the commission or prevention of an offense may retain such firearm or ammunition for so long as may be reasonably necessary. That's what we're inserting before necessary. Reasonably necessary for the purpose of any investigation in relation thereto, and where such investigation results in legal proceedings against any person for any such offense until the legal proceedings are finally disposed of, because you're going to need it as an exhibit in the case. And where legal proceedings, jumping down now to where no legal proceedings have been instituted against the person in respect of any offense. Well, we say instituted in the courts against any person of any offense mentioned in 2, the firearm or ammunition, as the case may be, shall be returned to the person who is proved to be the lawful owner thereof, or if no lawful owner is proved, shall be transferred to the authority for disposal in accordance with 102. And the request was for a time frame to be inserted within which the return is to be made. And I think that time frame related to a decision that no legal proceedings would be instituted. So the file is not kept open. These things are a matter of record. And so if the need arises, it can be checked that the decision was taken at X time, and the time begins to run after that decision is taken. I mean, the challenge really is that one may not know when that decision is taken, and so may not be able to ascertain when the time begins to run.
So
yes.
Minister, under the amendment to section 17 of conservative force, I think we had included a time period and adjusted as soon as reasonably practicable. Reasonably practicable. So I'm not sure if that will appease persons in terms of a timeline. So it's a similar provision on the.
So you don't really want to tie your hands. Again, when we're writing time frame, we have to be careful that we're not setting a time frame that cannot be complied with, and then the breach creates its own another set of challenges and liability on the part of the state. But I think we really are grappling with a situation where many persons who discharge the functions of the state and of government do not operate with timeliness and time frame in mind. And so things just go on and on and on, leaving, the public, members of the public who are on the other end in a quandary. So I think that's what we don't have to detain ourselves with this at this time, Chairman, about inserting the time, but we can just note it, and between now and our debate or reporting on the report, we could probably see how we can address it. Because the challenge for me is not so much the insertion of the time frame, but is how you will know when the time begins to run. What is the process by which the officer who has, you see, in a proper system, all officers are supposed to account for matters under their investigation. The way the JCF and the forces are structured is that you have superior and subordinate officers, and you really are to be held to account for the matters that are under your watch. And these matters are to be recorded, not oral dealings. So a superior officer to the constable, and the constable doesn't necessarily literally mean a constable at that rank, all right, is going to have to account for the matters under investigation by them. What is the progress? Where are you with it? So what offense did you suspect that was committed with the use of the firearm? What evidence do you require to bring a charge? How much time you need to gather that evidence? Build your case file, prefer the charge so that the person can formally answer. That's if the matter is going to court. And then you may have the other case where it's something that you may have to report to the FLA, and action is taken around licensing and fitness to hold. So when you think about it, you can really design your system for time frame, but it's just that people have to be held to account, and then you bear in mind that you may have unforeseen circumstances that may require extension of time or a bridging of time. But I think the committee, what could be recorded is that the committee considered whether a time frame should be inserted at 95.4 for the return of the firearm, and then having regard to what is provided for at 95.2, it was a little difficult to settle on a time frame, because even the 14 days that we propose, as the learned CPC point out, it may create a challenge in how it reads as against 95.2. And then we can go on in the interest of time, would be my suggestion.
Thank you, Minister. Okay, the next comment they had was in relation to section 97. And their recommendation was a proposed rewording. But if I recall, our discussion at the committee was to actually delete 97.
But different note, Mr. Richards, that the offenses were to be specified. Which of the many offenses where the person commits under the act? The clause was to be revisited, but the offense was to be specified. That's what my notes say. Where a person is convicted of an offense under this act. Any of the many offenses or
I'm being
specified offenses?
To say we're supposed to remove the mandatory minimum. Would be subclause B. Sorry.
It's where they're convicted of an offense in respect of which a mandatory minimum sentence.
Right, but recall we're not doing mandatory.
Provided.
For this part.
But I think we had agreed to revisit the penalties for the license regime and to remove mandatory minimums for the license regime. So if that is done, then section 97 would not be necessary.
That is my recollection as well.
I have no difficulty with what is the recollection by others.
Okay. The next recommendation from Practive again was at 108, in section 108. It is suggested that the Parliamentary Council redraft the provision that notices be split in two. From the policy side, we do not accept that because the provision only treats with the submission of notices.
I'm sorry, can you just point me to the section you're reading of proactives on the matrix?
It's at page 56. So they're saying recommendation in section 108, it is suggested that the Parliamentary Council redraft this section and that notices be split in two. That is, notices relating to status updates may be sent by post or mail, and notices requiring action should be delivered to the person concerned who shall be required by this act to sign for same confirming receipt or advertise twice at least once, at least 1 week apart in a publication in the daily newspaper.
Why are we forgetting that license authorizations are not granted at large, but through a very specific process, and that people have to be considered fit and proper, and that there has to be faith that the person is in a position to discharge their responsibility and to be in sufficient touch with the authority. And that once you get an authorization, you are under duty from time to time to be in touch with the FLA.
That's correct, Minister. So we did not support that recommendation. The next recommendation from them was at clause 109 in relation to the documents. So they're proposing to add, for the avoidance of doubt, a court or other body who examines the extract or a copy of documents may require that the original be produced if it deems it necessary. From our perspective,
Court always has that power, you know.
I thought so as well, Minister.
In the interest of justice, yes. So what you would do is that it is, again, we provide for procedure to take out the tedium of certain things. So anytime something is in dispute, you may be required to call the maker of the document, but if it is not in dispute, you can tender the document under a specified procedure. It's the interest of justice that you're aiming at. and not depriving a person of an opportunity. So we can't get into every minutia and specify every rule of practice in court. Sometimes the avoidance of doubt is necessary, but I highly doubt that this is one of them.
Okay. I'm not seeing anything else from Proactive. Actually, yes. They had proposed to make some amendments to the 4th schedule, but I think that they didn't recognize that that was already provided for. So they wanted to include in the 4th schedule the regional office at Discovery Bay, or any other regional office that may be established from time to time. And my notes shows that we had made a slight amendment to include a number 3 in the 4th schedule to be any other location designated by the minister. But the regional office for St. Anne is already there, is already provided for. So they do have some recommendation in respect of the 6th schedule as well, in terms of how the provision for the penalty is drafted. So they say it is proposed to insert requirement applicable to a person authorized to carry a firearm in public place. We word the section, or we word the penalty to read, where a person will be liable to conviction of an offense under this section in circumstances where the offense only arose due to inadvertent failure to be in possession of a firearm authorization held by that person, which had previously been granted. That person shall not be liable for that offense, and instead shall pay an administrative fee for the oversight to the authority. The sum of that fee to be prescribed by the minister from time to time. From our perspective, members, we would have already outlined our difficulty with actually implementing a fixed penalty regime in terms of the administrative burdens on the police as well as the FLA. So I'm wondering, well, Minister.
Well, my comment is that I bear in mind that any provision in the law for fixed penalties is not going to be implemented until the fixed penalty regime is fixed. We came through DRMA fixed penalty and finish it in fixed penalty system outside of the Road Traffic Act, and even the Road Traffic Act system needs to be addressed. But you didn't hear me say that, right, DPM Chairman?
Sorry, Minister, members. Minister DPM had to step out for a few minutes to deal with something urgently, so
Okay.
he'll be back shortly.
Right. All right, I will assume the chair until he resumes.
So, Madam Chair, for me, the point that Steve made though harks back to the decision that was made in respect of a particular section already. So I think it was decided there to allow for a time period or, yes. So the adjustment to the provision in the 6th schedule would have to reflect the adjustment that was made in relation to the section.
Very well, Madam CPC. All right, so that responds to that. We can move on.
The next comment they had was in relation to, it's the same 48.2, the amendment to the penalty provision. I would have discussed that as well, Minister, on the and we're going to clause 48.
Okay.
That will be the end of this matrix.
Just a second, Ron, Nadine. What happened to the comments from the JDF in relation to clause 111?
Oh, clause 111, sorry.
Yes, you are looking at the practice Jamaican, but I think we're omitted to. Yeah, they had quite a bit. Quite cool, so.
So they had proposed that the following wording be added to clause 11, notwithstanding any provision of this act, but with the exception of section 29, marking of, sorry, I'm not sure.
So, Mr. Richard, in respect of this JDF proposal?
Well, in looking at this, we didn't think it was necessary because outside of the marking requirement, the act does not apply to the JDF.
But I'm sensing that they're saying, so this act shall not apply to any member or officer of the JDF whilst on authorized duty when carrying out a function so authorized to do.
Right.
So,
so
it means it would apply in other circumstances.
Right. So A says to any firearm or ammunition, the property of the government of Jamaica, which will also include JDF, except when it's in the possession of some person other than a person authorized by or on behalf of the government of Jamaica to be in possession of such firearm or ammunition.
Right, let's look back at it a little more before we dismiss it. So it is proposed that the following wording be added to 111. Let's just pause and 111, with the exception of section 29, marking of firearms, 68, grant of firearm authorization by the minister. This act shall not apply, A, to any firearm or ammunition, the property of the government of Jamaica. So they're saying, notwithstanding any other provision of this act, but with the exception of 29 and 68, by authors, this act shall not apply. I probably need a translation of the recommendation there.
Minister, I think there is more clarity when we look at the second part where that begins with recommendation, and it's people who are not necessarily directly employed to the JDF, a member of the armed forces of a state other than Jamaica who is attached or seconded to the JDF is one of the categories that they're putting forward.
But those persons would be authorized because they would have government of Jamaica weapons. So they would fall under category A1.
I don't know if they're talking about the weapon or the individual being in possession of the weapon.
Sorry.
You're saying that the weapon at all times has to be a government of Jamaica weapon for 111?
Yes, it will be issued by the JDF.
I'd like to hear a little bit more. I mean, I've read it, but I'd like to hear what was the ministry's response,
So
Mr. Richards, Mr. Bailey?
We were saying that outside of those two sections which were outlined in the chapeau, the APA does not apply to the JDF or to the security forces.
The Visiting Forces Act would have dealt with the
111.
the authorization for a person who is part of it. I think that law already satisfies. Well,
111?
but
No, I just want to see the exclusion provision. Just remind me where it is.
would be a government of Jamaica firearm. That's the issue. Is the firearm in every one of the situations they have from A to B, going to A to E. They are firearm that belongs to the government of Jamaica. That is what we need to look at and decide.
Well, not all of them. Not all of them, not E.
E refers to
firearm, but the Visiting Forces Act, in my view, already authorizes the use of weaponry that is not. That's how we did, yeah.
So he would refer to the visiting forces, Nadine.
Yes, I'm agreeing that law would be the place to deal with this issue, not their firearms bill.
I'm just taking some time to consider it.
The cadet, the person associated with the cadet organization, any firearm that the cadet corps gives to them, would that also be belonging to the government of Jamaica?
Yes, JDF.
The cadet?
Yeah.
The ones in the high school?
No, they don't arms and fast, they have to come to the camp first. They be used, trained by the JDF.
No. The weapon that they use when they're at school doing drills.
No, man, they're not allowed to drill with weapons in school again.
Oh, that's stopped. Okay, so my child had a weapon. Sorry. Okay.
I had two, but we remove all the weapons from the school. When they come and camp at the JDF with a Burke or upper camp, they're allowed to drill with the old Chaudhry's rifle. But they're JDF rifles.
You're mentioning the operator of a museum or a person employed in the museum. Would that person be okay as well, Ron?
Employed museum. This would be the JDF museum. So the weapons would have been acquired by the government of Jamaica.
Not necessarily. No, not necessarily. If it is a museum and what is displayed is of a historic nature, it need not have emanated from the government of Jamaica. I think we have to. I don't think that assumption can be made in the case of a museum. That's what I'm saying, Ron.
Yeah, understood, but they would have to get authorization from the minister to be able to have it in their possession.
The old firearm.
Right. So the minister, all firearms relating to the JDF would get authorization from the minister. That would be the grant of authorization from the minister under Section 68.
Okay. No, you're satisfied.
They're saying that the act would apply to them in some circumstances and not in others?
That's the one where they're defined, the registration. The markup there aren't the government arms. So if they're carrying the government arms, what applies to them is the JDF Act. The only part of this act would apply to them is that all their firearms have to register to the Institute of Forensic Science, marked and registered, and the ballistic fingerprints are retained there and all, etc. The rest of the arm would not apply to them. They come on the JDF Act. JDF Act have a wide range in it. You look at the minister. That's how they go to the toll. The toll authority to give them permission. The act allows them to go anywhere in Jamaica anytime they feel it's in the interest of their.
I'm just seeking to understand the recommendation, DPM. I understand that special considerations apply in respect of the Army having regard to the duties performed. Yeah.
So they're saying here, no, notwithstanding any other provision of this act, but with the exception of section 29, mark of firearms, 68, grant of firearm authorization by the minister. This act shall not apply to any member of the or officer of the JDF whilst on authorized duty when carrying out a function so authorized to do. Possess a firearm, a prohibited weapon, any ammunition or any explosive substance in the course of or for the purpose of the member or officer authorized duties or employment when so authorized by the higher command. This could cover weapons left in storage with the JDF. So essentially
outside of markings of the firearm and grant of authorization, what of the Firearms Act that applies to members of the JDF while doing official duties?
According to this recommendation, nothing. This request, I think what I want is to be explicitly stated. If not, it would be. I don't know if it's necessary really. I'd be advising the minister because my understanding is that that's all that applies to them. Okay, stated.
Can I get your views? May I get the views of the CPC through you or the SG through you? SG, CPC, and Ms. Wilkins.
Well, I agree with what had been stated by the ministry's team as to what is set out in 111. It seems that, yes, they do want to be expressly mentioned, but I don't think that's possible given how the provision is cast, because we're already referring to them in terms of them having firearms or ammunition, which are the property of the government of Jamaica. So it's not possible to refer to them outside of that, because then it begs the question of that they don't fall within the more general language, which is not the case.
Nadine, through you, Chair.
To be honest, Minister, I'm still stuck with the museums. I was trying to remember if there was a provision in the bill to deal with historic things. Like if somebody digs up somewhere and finds a musket and it's displayed in the JDF museum. I'm just trying to figure out if, even though I've heard what Ron says, I'm just wondering if such a weapon would be covered under the exemption granted to the JDF. I just wonder if I don't know, CPC, is there a provision, I can't remember, is there a provision in the bill that would cover such a weapon?
What I see here, if you look at the recommendation, essentially what they're saying is that for the areas that I've mentioned that might be questionable, you're giving the Chief of Defense Staff the authority to really authorize it. So if this law doesn't mention the museum or the cadet court specifically, then once the CDS authorizes the camp or
perhaps we can benefit from the perspective of the SG through you, Chair, having heard the CPC and Ms. Grant.
Yeah, go ahead. SG is coming. I'd love to hear that.
I'm sorry, I missed the discussion, so I apologize. I really am not able to weigh in. I'm sorry about that.
I don't see how to respond to this. They recommended they want this one big specific. They really ask for a blanket authorized to give the CDS to cover the other spots.
So the explanation I would accept from the response so far, that although it seems to be out of an abundance of caution and wanting the authority to be given to the CDS, it doesn't seem that it is necessary that for that provision.
That's my
Yes.
Minister said that. That's
For
really
their
what they're looking
request.
here is specifically allowing the CDS to broaden their privilege to a number of years. That seems to be somewhat normally when the visiting forces come there, that covers them, you know, and we give permission for the visiting forces.
Also,
Yeah.
this is-
We agree that that one is not relevant. And I guess they can apply for an antique firearms collector's license. It's the case that I was mentioning.
The JDF trainee is really a cadet, officer cadet, etc. I love the advice of this, as you said, it, Minister. But it doesn't look necessary. I think the current law allows them to, and the new law does not really take away any of their privileges.
I guess they wanted it to be permissibly clear, but
We're still erring on the side of privilege for the JDF, but
Well, they don't really lose anything if the recommendation is not accepted.
no, they lose nothing.
They're- right.
The essence of what I see here, you could ask the SG to take a look at it them again, and
Excuse me, Chair, I'm not sure if you heard me earlier. This is Marlene Aldred. I missed the discussions. I'm saying I'm sorry, but because I missed the discussion, I'm not able to weigh in.
no, I'm saying I'd allow you time that you could look at their recommendation. They're just looking at essentially that the law exempts the JDF except for the markings, etc. And their recommendation is to state that more explicitly and give the CDS a broad remit in authorizing the kind of what would appear to be gray areas, like the JDF museum where they might find firearms and it wasn't procured in the normal way. They find it in some archaeological dig outside old fort, or a cadet corps or a cadet officer having a firearm, but they are not yet full members of the JDF. But the weapons are the JDF weapons. So I don't think that is not quite necessary, because JDF in training, they're using arms that are approved for the JDF use. And they would only get them to use when the CDS gives permission for the training officer to get them. Similar to the cadet corps. What I would say, you could look at it and make a recommendation later, but it doesn't seem to be necessary from what.
Sorry, Chair, it is really a policy issue, you know. So at the end of the day, I think it will be whether you really want to specifically give that kind of power to the CDS or not.
In relation to these specific items, it doesn't relation to the cadets and areas under their authority anyway, but they are not specifically members of the JDF.
Right, but the power is being given to the CDS. I'm saying at the end of the day, that is what you would want to consider, whether you really want to give that power to the CDS, or if you want to give the power elsewhere or not to include it at all. But at the end of the day, that's really a policy decision.
It become an authorization for the minister again, the Minister of Defense.
Right, so it could be someone else like the minister, yes.
Minister, let's give it a thought.
We could proceed. We could note the recommendation and proceed, and just report that no decision had been taken. It was considered and no decision has been taken, because it is felt that since the law already exempts the JDF, there was no loss if it were not to be included, and further consideration would have to be made. And Chairman, you'd have to discuss that with the Minister of Defense.
It's a policy issue.
Yes.
Also don't need to be stated here. We can put that on the table.
We could discuss this matter in the NSC, Chairman. Yes.
All right. Next comment goes on 116, continuum services. 116. We have done it. No. Has schedule.
So there. Schedule amendment.
But this also is a policy to designate the armored storage facilities. We have actually gone through the main body of the bill in terms of.
I think though that it's recommended that all JDF armories are designated approved temporary storage
I think we agreed to
facilities.
that.
Yes, I was about to say yes.
We agreed
That
before.
is, yes, we had.
We have agreed to that before.
Yes.
We agreed to this.
Right.
Yeah. What else do you have there?
We have some additional definitions, which would have, well, we're going to this already.
Proactive one is about,
We finished proactive.
no, recommendation for schedule.
Yes, we went
schedule.
to finish proactive.
Okay, so-
Whereas we're
so
almost
the
at an
matrix.
end, Chairman. We're almost at an end.
Yes, Minister, thank you very much. I think, man, I would quote my colleague, to sleep on the same side you were.
Please, Chairman, I asked you to do that.
DPM, you and I have a whole lot of work to do out west. So
The member doesn't know. You see, member, this is a special ministerial relationship, so. And she's my neighbor.
no, I am your MP.
She's my member, right? So I have to account to her.
Absolutely.
Well, Chairman, notwithstanding that, I don't wish for any biased treatment to in this committee at all.
No bias, but a little favoritism sometimes don't do badly when there's such a.
Chairman, I think you better pause while you're ahead. And not-
Through your chair, Mr. Richard, please remember that there is a part 2, not a lot on that section of the matrix, which is not included in the one that we're seeing right now.
Where's that part 2? That's one page, no?
May I suggest, Chairman, if we're going to go to the part 2 of the matrix, we just probably give a 5 to 10 minutes refreshing break without people logging off.
Where's the part 2 announcement?
It's,
I saw it in your.
I have a print, Miss. Thank you for my print.
Yeah.
But there's some recommendations from JDF to go through.
Some more recommendations from JDF?
Yes.
Well, these are 20 pages, so it's not.
It's the same. One page here. See, this is it. This is part 2.
As Jackson.
Chairman, may I propose a 5 to 10 minutes break without our logging off?
Sure, Minister.
Just muting the mics and off camera, just to stretch our legs.
Take.
Yes,
10
just a
minutes.
refreshing break. Yes.
Get a cup of tea and. See, is it Mr. Jackson, the member of parliament and the minister, is in our constituency?
I never knew that we were permitted to do constituency matters while the committee meeting is convened.
That she'll not be sneaking off the bed when you're in the office.
I will suggest that you take the minister's advice.
I'm taking a break.
So I would say we come back at 1:45. Yes, at 1:45, 2:45. Very well. I'm going to be stepping away.
It's 1:45.
Oh, at 1:45. Thank you, Senator Golden.
Jamaica and its workforce are advancing quickly. Life-changing opportunities are arising. you need training and support. We are the Renewed Heart NSTA Trust, committed to providing new and emerging skills training and opportunities. Come to Heart. We'll help you claim your place in the workforce of the future.
How do bills become law in Jamaica? Laws are made to create order, to ensure our safety, and to protect our rights against abuses by other citizens, organizations, and even the government itself. A bill is a proposal for either a new law or for a change to an existing law. Jamaica's parliament is responsible for making our laws, and that responsibility is shared between two houses. There are 21 parliamentarians appointed from both political parties to the upper house, also known as the Senate. And there are 63 members of parliament that we, the people, elect to the lower house, also known as the House of Representatives. To pass a law, there is a minimum of 6 stages required in each house. The process can begin in the upper house by a senator or in the lower house by your member of parliament. And their proposals for a new bill can certainly start with you, the citizen. Now, since the process often begins in the House of Representatives, let's start there. 1. The first stage begins with the introduction by the minister responsible for the bill, followed by the first reading of the bill by the clerk to the houses. This clerk is more like the CEO, the Chief Executive Officer for the Parliament. An announcement of the bill is published in the Gazette. This is a public newsletter that the government uses to inform the citizens of what the Parliament is doing on your behalf. 2. The second reading begins with a summary of the bill by the minister. The main reasons for the bill are discussed both by the government and opposition members to determine if Jamaicans would really be better off with the new law or changes to an existing law. A vote is taken by the House to determine if the bill will move to the committee stage. Sometimes before going to that stage, the minister responsible for the bill can recommend the use of a joint select committee. It's called joint as its members are taken from both the upper and lower house. To benefit from greater consultation, the committee is empowered to invite the public to share their views of the bill in writing or in person, and does so through radio, TV, and newspaper adverts. This joint select committee submits its recommendations to the House of Representatives. The House debates this report, and a vote is taken to determine if the bill should go on to the committee stage, where it is examined by a committee of the whole House. Yes, that's the name. And that's what it is, a committee of all the members of Parliament that carefully examines each clause and makes improvements to ensure the bill will achieve its objectives. As chairman, the Speaker of the House monitors the process to make sure the rules of the House are obeyed and the process moves along smoothly. 4. The committee of the whole House examines the bill clause by clause, then sends its recommendations for changes to the House of Representatives. This is called the report stage. 5. The bill then passes to the third reading to allow a final opportunity for MPs to make changes before it is sent to senators in the upper house. 6 to 10. In the upper house, the senators go through the same steps we just described. If any changes are made, the bill has to be returned to the House of Representatives for their discussion and approval. Now, if the bill had started in the upper house, it would also have to be returned to them for approval of any changes made by the lower house. 11. Throughout the entire process, the bill is being checked by the Legislative Council. That's the Parliament's lawyer. But before the last step, a copy is sent to the Attorney General of Jamaica for final review and certification. 12. If all is well, the bill is sent to receive the royal assent from the Governor General as the representative of the Queen, Elizabeth II. The bill is now an Act of Parliament. The Act is gazetted, and the rights of Jamaicans are further preserved and protected by a new law.
This is our home, Jamaica, and tourism is the lifeblood of our country. Let's all feel good again. Whether with family or friends, we want you to enjoy your staycation.
We have to ensure that they are comfortable, they feel well protected.
New standards are in place to ensure your safety. We are here to serve you better, so you can have the best experience. Come out and rediscover Jamaica.
We are ready.
We are ready.
We are ready.
Rediscover Jamaica.
Heartbeat of the world.
Watch yourself online, that's what my crew say. Make it a new day. I'm reminded by the Broadcasting Commission. We the BCJ. What if it was your friend in the mix? What if it was your sis in the pit? What if you want a terrorist watch list? What if? Suppose that one. What you do? Don't like, don't comment, don't click. Report it, block it, don't make it stick. Don't trust everybody on the internet. Use it to step up your intellect. So online you have to be safe too. Don't believe the rumors or the fake news. Don't go everywhere they try to take you. Protect the kids or they find a way to. What if it was your friend in the mix? What if it was your sis in the pit? What if you want a terrorist watch list? What if? Suppose that go on. What if? Wait up, please.
Brutality isn't a legality. There's no rationality as to why this abnormality should become a mentality. A mentality which kills and tortures. Are you really telling me you're afraid to speak up because you might be called an informer? Let us break the barrier of brutality and enforce it with alacrity. If you know someone who has been victimized, I charge you to I, interrupt their situations before their O. Oppressor continues to L, lurk in their lives. Let us E, extend our hands to our brothers and sisters who are being victimized, and N, never see violent acts and ignore them. Let us C, come together and be the E, example, so we may end a barrier on brutality.
Get vaccinated. Everybody get vaccinated. Good. Get back to life, get vaccinated. Good. Protect your life, get vaccinated. Good. Protect your family. Aye. Before me do road, me have to get vaccinated. Good. You do it already, you get me ratings. Good. It's free for the public, keep your savings. Good. If you not do it yet, the risk you're taking. Protect for your life in this pandemic. Good. COVID and nothing for you play with. Good. And sanitize and mask for wearing. But if we move forward, we get vaccinated. If you a barber, shopkeeper, taxi driver, go get vaccinated. Good. Whether dance or church, me a preach like pastor, go get vaccinated. Good. Follow the soldier, the police, the frontline workers, and go get vaccinated. Go get vaccinated. Good. All hairdresser, go get vaccinated. All street youth, get vaccinated. Good. Get vaccinated. Good. Everybody get vaccinated. Good. Get back to life, get vaccinated. Protect for your life, get vaccinated. Good. Good. Go get vaccinated. Good. Everybody get vaccinated. Good. Old and young get vaccinated. Protect your family, go get vaccinated. Good. Good. Good.
Here is a special parenting message brought to you by the National Family Planning Board, 5 Sylvan Avenue, Kingston 5. The way we treat our children directly impacts what they believe about themselves. That was a special parenting message brought to you by the National Family Planning Board, 5 Sylvan Avenue, Kingston 5.
Jamaica, home of the resilient, passionate and hard-working.
a people and a nation who have achieved and defied all odds, working to keep their economy growing, their country thriving, from investments made in innovative opportunities and exports demanded globally. We have a vision, now within our grasp, where Jamaica becomes the place of choice to live, work, raise families, and do business. We will not let go of this vision. We will grow. We will overcome these challenging times and look to the future with hope and positivity. These are special times. The world as we know it has changed, but home will always be in our hearts. And in Jamaica, you can always find a home. Think you know Jamaica? Look again. You will be surprised.
No one is immune to mental illness. Your age, race, gender, social class, or economic status is no match for addictive behaviors, anxiety or eating disorders, depression or schizophrenia. What is having a good social support system. As the saying goes, in times of test, family is best. Unfortunately, many are denied the benefit of the support of family and friends because of stigma and an oppressive silence around mental illness. Let's put an end to the silence.
Speak up.
Speak now.
End the stigma.
Share your story. End the stigma.
A message from the Ministry of Health and Wellness.
I'm looking for a successful career in being a software developer, a software engineer, and I want to create softwares or apps for myself. So I want to gather a team with my colleagues to execute the visions that I have or even visions that they have as well.
Become the hero on the scene by taking the COVID vaccine.
Be a hero for your loved ones and get the COVID-19 vaccine. Visit a vaccination site to take your first or second dose of the AstraZeneca vaccine, or be one and done with the single-dose Johnson & Johnson. Visit www.vaccination.moh.gov.jm or call 888-1-LOVE to find the site nearest you. Jamaicans, the vaccines are proven safe and effective. Let's get vaccinated so we can get back to life. A message from the Ministry of Health and Wellness.
Become the hero on the scene by taking the COVID vaccine.
Be a hero for your loved ones and get the COVID-19 vaccine. Visit a vaccination site to take your first or second dose of the AstraZeneca vaccine, or be one and done with the single-dose Johnson & Johnson. Visit www.vaccination.moh.gov.jm or call 888-1-LOVE to find the site nearest you. Jamaicans, the vaccines are proven safe and effective. Let's get vaccinated so we can get back to life. A message from the Ministry of Health and Wellness.
You know who have the gun them. Stop going like you don't notice. You notice.
Jamaica and its workforce are advancing quickly. Life-changing opportunities are arising. You need training and support. We are the Renewed Heart NSTA Trust, committed to providing new and emerging skills training and opportunities. Come to Heart. We'll help you claim your place in the workforce of the future.
This is our home, Jamaica, and tourism is the lifeblood of our country. Let's all feel good again. Whether with family or friends, we want you to enjoy your staycation.
We have to ensure that they are comfortable, they feel well protected.
New standards are in place to ensure your safety. We are here to serve you better, so you can have the best experience. Come out and rediscover Jamaica.
We are ready. We are ready.
We are ready.
Rediscover Jamaica.
Heartbeat of the world.
No one is immune to mental illness. Your age, race, gender, social class, or economic status is no match for addictive behaviors, anxiety or eating disorders, depression, or schizophrenia. What is having a good social support system. As the saying goes, in times of test, family is best. Unfortunately, many are denied the benefit of the support of family and friends because of stigma and an oppressive silence around mental illness. Let's put an end to the silence.
Speak up.
Speak now.
End the stigma.
Share your story. End the stigma.
A message from the Ministry of Health and Wellness.
What if they knew that you abused her? Her family?
Mr. Jones.
And your colleagues, how will they look at an abuser? When the law comes knocking, you'll have nowhere to run.
Mr. Brown, you're under arrest. Please get up, hands behind your head and interlock your fingers.
Turn your back on abusers. Report gender-based violence to the police. There's no excuse for abuse. Call the Bureau of Gender Affairs at 876-754-8577.
People always say government must be held accountable. But it's whose job to keep government accountable, and what that really mean? Well, you see, when ministers and public officials have to provide answers for decisions made and can face consequences for those actions and decisions, that means they're being held accountable. Keeping government accountable is a key responsibility of our elected representatives, and the Parliament provides special tools or mechanisms just for this. As citizens, we need to understand how they work so we can play our part to ensure that the members of Parliament we elect are using the tools and doing their job well. Here are 4 of the primary tools you should understand and talk to your MP about. Tool number 1, Minister Statements. To effectively monitor the government, MPs need to stay informed. Every Tuesday when Parliament sits, different cabinet ministers are scheduled to give an update on decisions they're making on our behalf. These updates are called Statements by Ministers. They cover a wide range of national issues that other MPs, media, and citizens may have questions about and wish to examine further. That brings us to tool number 2. What do you do when you want information? You ask questions, and that's why we have Question Time. Both opposition and government MPs can submit questions to the Prime Minister or Cabinet Ministers for details on, for example, how a contract was awarded or expenditure to purchase tablets for schools. So if you ever have a question for a government minister, try asking through your MP. After all, that's why they're your political representatives. They should represent your questions and concerns to the government. Tool number 3, Parliamentary Debates. When cabinet ministers present the government's proposals for new policies, laws, and programs, parliamentary debates allow both opposition and government MPs to air concerns, make suggestions, and endorse proposals. If you ever watch those debates, you know they can get a little fiery. But the debate is important as it informs decisions and continues until a vote is taken on the way forward. Then we have tool number 4, Parliamentary Committees. The general sittings of Parliament are not always sufficient for detailed examination of government's work, so oversight committees are formed using government and opposition members to do just that. Some committees like the PAC and the PAAC are in place for an entire parliamentary term. Their job is to monitor the use of public funds to find ways to increase value and efficiency while reducing waste and corruption. Cabinet and state ministers are not appointed to oversight committees since they are a part of the government. Some committees are formed when a need arises. For example, joint select committees are formed to review draft policies or legislation or to probe other matters of serious national importance. Members of these committees are both opposition and government MPs and senators, and these committees will usually invite citizens to share their opinions, concerns, and recommendations. So there you have it, 4 accountability tools of Parliament that are used to make sure government run right. Visit jampja.org to find contact information for your MP. Invite them to meet with the community so they can better represent your issues and concerns in Parliament and keep government accountable. Get involved and let's make Jamaica land we love, Jamaica land we own, and Jamaica land we run well. A message from the Jamaica Accountability Meter Portal, funded by the European Union and the Inter-American Development Bank in partnership with the Private Sector Organization of Jamaica.
Crime is Jamaica's #1 threat. As we stay apart while working together to fight COVID-19, we must all live good and unite against crime and violence in Jamaica. Live good means talk it out, don't fight it out. We must live good to build a safe Jamaica. Stay home, stay safe, live good.
To improve a school? Do you wish there were a way your community could get funding to improve a school, health center, sports program, and more? There is! It's the Constituency Development Fund. Here are a few things you probably didn't know about the CDF and how you can make it work better for you. The CDF policy promotes citizen participation in community development and the protection of taxpayers' funds. It outlines that MPs are to meet with citizens at least once every 2 years to agree on the projects needed. You know, it used to be once a year? We should really go back to that. Projects developed without community consultation are not to be approved by the bipartisan CDF Parliamentary Committee. There are 26 government agencies that implement projects, usually for a small fee. Funds are provided directly from the Office of the Prime Minister to the implementing agency, not through the Member of Parliament. The CDF unit monitors project costs and implementation, so if you have questions about how the CDF are run in your community, contact them. To ensure no one project or community gets all the funds, there are 6 project categories with spending limits for each. There must be no less than 5 and no more than 20 projects each year. To learn more, visit jampja.org to view your MP's CDF info and tell them how this fund has impacted you. If you don't see your MP's CDF reports, then put them under little pressure, man. Call, tweet, email. Ask them when they'll submit it and when is the next CDF meeting. Change is possible. It's already happening. What we need is you. A message from the Jamaica Accountability Meter Portal, funded by the European Union and the Inter-American Development Bank in partnership with the Private Sector Organization of Jamaica.
Here is a special parenting message brought to you by the National Family Planning Board, 5 Sylvan Avenue, Kingston 5. The way we treat our children directly impacts what they believe about themselves. That was a special parenting message brought to you by the National Family Planning Board, 5 Sylvan Avenue, Kingston 5.
Together, we can create a safer Jamaica for our children. We need to get the guns and save our country.
Hi everybody, my name is Jerome Smith and I'm the Principal Director of Forest Operations here at the Forest